an electronic communication device in a drug transaction, 1 count of possession of a weapon by a prohibited person, 1 count of possession or use of a weapon in a drug offense. All 6 of those counts are Class 4 felonies. 1 count of unlawful flight from a law enforcement vehicle, a Class 5 felony. 1 count of causing criminal damage. 1 count of carrying a weapon during the commission of a felony offense. 1 count of drug paraphernalia possession. Those 3 are Class 6 felonies. And finally, 1 count of causing damage in a hit and run. That's a Class 1 misdemeanor. I have found probable cause to support these new allegations. I've also appointed a lawyer to defend you.
Thank you.
Your next court hearings on those new allegations will be a status conference March 18th and then a preliminary hearing March 20th. They will both be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $100,000 secured appearance bond. The other 2 matters you're here on are both allegations that those new charges violate Term 1 of your probation. I have appointed a lawyer to represent you in both of those probation cases. Your next court hearing in the probation matters will be a revocation arraignment. That will be March 19th at 8:30 in the Superior Court downtown. On one of the probation matters, you have a $2,500 secured appearance bond. On the other, you are not eligible for release on bond. So here's what that means. It means you will be held in custody without bail at least until you see the probation judge on March 19th. If on March 19th, the probation judge determines you are bond eligible on that probation case, you could then look at posting the bonds on the other 2 matters to be released from custody.
And that bond would be $100,000?
It's 100,000, excuse me, it's 102,500. It's 100,000 on the new charges, 2,500 on the second probation case. So 102,500 total.
Yes, ma'am.
It is secured appearance. So if you get to that point, though, you could use a bonding company to post that.
Absolutely. Thank you.
Okay. Any other questions, Mr. Davidson?
And then you say it's secured, so that means that it's not all cash?
Correct.
Okay. Good. Thank you.
Okay. Thank you, sir. You can step back and get your paperwork. Is it the 47 number? Yeah. Did somebody just connect with the phone number ending in 47? If so, can I please have your name?
Mike Lopez, court interpreter. Good morning, Your Honor. My apologies to the court. My computer doesn't want to play today.
No problem, Madam Interpreter. I don't think that we have any Spanish matters. I haven't been told anybody. You're a Spanish interpreter, right?
Yes, Your Honor.
Okay. I don't have anybody marked, but since I have you, could you make an inquiry of the gallery? And if nobody needs your services, you can go ahead and get on with your day.
Thank you, Your Honor. ¿Hay alguna persona que necesite ayuda en español? Si necesita ayuda en español, levante la mano, por favor.
No hands? Okay, I'm told no hands were raised. So thank you for joining us this morning, Madam Interpreter. You're free to disconnect.
Thank you.
Okay, can I please have Karen Almestica into the courtroom, please? Tommy Jones, if you would work your way to that second chair. Can I have your name and date of birth, please?
Karen Almestica, 49-1993.
Thank you very much. It's Karen.
Yes.
Okay, thank you, Ms. Almestica. You are here on 2 different matters. The first matter that you're here on is allegations of new charges. Those allegations are 2 counts of narcotic drug possession for sale, 1 count of dangerous drug possession for sale. Those 3 are all Class 2 felonies. 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of obstructing a public highway or thoroughfare. That's a Class 1 misdemeanor. I did find probable cause to support those new allegations, and I have appointed a lawyer to defend you. Your next court hearings on the new allegations will be a status conference March 18th and then a preliminary hearing the 20th. Those 2 hearings will be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $50,000 secured appearance bond. The second matter that you're here on is a probation violation warrant. In that case, a petition to revoke your probation has already been filed. It alleges violations of terms 3 and 5. I have appointed a lawyer to represent you in those probation proceedings. Your next hearing in that case will be a revocation arraignment March 19th at 8:30. On that probation matter, you are not eligible for release on bond. That means you will be held in custody without bail at least until you see the probation judge on March 19th. Because you're not eligible on that probation warrant at least until the 19th, I encourage you not yet to try to post your bond on those new charges. I would say wait until you see the probation judge. If on that day the probation judge either releases you or gives you a bond on the probation case, then you could post that to be eligible for release on both. Do you understand that information?
Yes.
Thank you very much. You can step back and get your paperwork. Francisco Bracamontes to the podium in the courtroom, please. Steve Talavera, if I could ask you to work your way to that second chair. Can I have your name and date of birth, please, sir?
I'm the living man, Francisco Everardo Bracamontes Jr., not the corporate entity here in question. My date of birth is 7/22/1981.
Say the year one more time for me, please.
1981.
Thank you very much, Mr. Bracamontes. You are here on allegations of new charges. The allegations are 1 count of aggravated assault, a Class 3 felony, 1 count of aggravated assault by impeding breathing, that's a Class 4 felony, and 1 count of unlawful imprisonment, a Class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th, and then a preliminary hearing March 20th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a secured appearance bond in the amount of $50,000. If that bond is posted prior to your physical release from custody, you will be affixed with an ankle monitor. If you post that bond and you are released on that ankle monitor, you cannot have any contact whatsoever with the alleged victim or any alleged witnesses of the underlying allegations. You also cannot have contact with any minors. You can't possess any weapons, drugs without a valid prescription, or consume any alcohol if you're released. And last, whether or not you're released from custody, you are ordered to comply with the terms of any orders of protection or orders against harassment, if any have been or might later be served upon you.
What does a secured bond mean?
It means that you can use a bonding company to post it. It does not have to be posted in all cash.
Okay.
Any other questions?
No.
Okay. Thank you very much. You can step back and get your paperwork. Tommy Jones to the podium in the courtroom, please. Crystal Harvey, if I could ask you to work your way to that second chair, please. Can I have your name and date of birth, please, sir?
Tommy Jones, January 23rd, 2000.
Thank you, Mr. Jones. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. That indictment contains 1 count of possession of a weapon by a prohibited person, a Class 4 felony, and 1 count of discharging a firearm in the city limits, a Class 6 felony. The grand jury warrant alleges that both of those offenses were committed September 4th of 2023. I have appointed a lawyer to defend you against those allegations. Your next court hearing will be an arraignment hearing March 19th. It'll be at 8:30 in the Superior Court downtown. On that grand jury warrant, you have a $25,000 secured appearance bond. If you post that and you are released, you cannot possess any weapons once you're released from custody. Do you understand those conditions?
Yes, Your Honor.
Thank you, Mr. Jones. You can step back and get your paperwork. Steve Talavera to the podium in the courtroom, please. Michelle Gearing, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Steve H. Oliveira, 1987.
Thank you, Mr. Talavera. You are here on 2 different matters. The first matter that you're here on is a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing criminal felony drug case. In that existing criminal case, you have a lawyer already assigned to you, so that lawyer will continue to defend you. Your next court hearing in that case will be a status conference March 18th at 8:30 in the Superior Court downtown. On that existing criminal warrant, you have a $500 secured appearance bond. The second matter that you're here on is a child support arrest warrant. In that case, the family court judge assigned to your family law case has issued a $3,000 cash purge. That cash purge is the amount that you must pay in cash in order to secure your release from custody on that child support warrant. Whether or not you post that bond, whether or not you post the cash purge and the bond on your criminal case and you're released from custody, you have to attend a return hearing on the family court warrant. That hearing will also be the 18th, but it's going to be at 10 o'clock in the morning instead of 8:30.
Okay.
So if you pay all these amounts and you're released from custody, you then have to get yourself back to the court on the 18th, check in with the criminal court, then go to your family court hearing.
Okay.
If you don't pay all these amounts, then you'll stay in custody. MCSO will transport you to court on the 18th.
Okay.
Under Arizona law, I cannot modify, eliminate, or reduce the amount of the cash purge on your family court warrant. I am, however, required by Arizona law to ask you 2 questions. I will tell you before I ask you these questions, Mr. Talavera, you are not under any obligation to answer them. You can say, no, thank you, pass, I don't want to answer. All of those things are completely acceptable. First question is there anything you want the court to know about your present ability to pay the cash purge on the family court warrant?
Yeah, we won't be able to do that because of the situation. I lost my job since I was here 3 months ago. I was in here for 3 months. I lost my job. I lost my house. Basically, I lost everything, so I'm not able to pay that at all.
Okay. Second question that I am required to ask you, again, you do not have to answer this question if you don't wish to. Is there anything you want the court to consider about being held in custody until and unless that amount is paid?
Last time I was released, the family court had released me on a certain date, but then that's when Thanksgiving happened, and then basically it overlapped. I was still in custody, so whenever I was released, I was already wanted again because they released me too late. I was supposed to pay the $200 bond that I had on child support. I was supposed to pay it, but they released me already past the due date. So I was already wanted once I stepped out of the gate again. Like they said,
you're saying the warrant that you were arrested on that I'm seeing you on right now, that family court warrant was issued because you didn't pay an amount that you were supposed to have paid while you were still in custody?
Yes.
Okay. So I hear you. I understand the circumstances. I can certainly understand how that could be frustrating. I don't have the authority to change anything about that. So I will affirm that cash purge. You will have to pay a total $3,500 to secure your release. $3,000 of that is the family court cash purge. So it sounds like you are not going to pay that, which is fine. If you do pay that, please make sure you get to the family court specifically, because the family court judge is the one that has the ability to make orders that sort of rectify this situation, or at a minimum make sure the same thing doesn't happen again. So I'm not the one that can make those orders, but the family court can. So remember to bring that up with the family court judge when you go to that hearing on the 18th. Explain the circumstances to the family court judge, and whether or not that judge can change anything that happened in the past, that judge can at least make sure that you're given enough time to make whatever payment comes next while you're out of custody, so that the same thing doesn't happen again. Okay, any questions, comments, concerns, Mr. Talavera?
No.
Okay, thank you very much. You can step back and get your paperwork. Crystal Harvey to the podium in the courtroom, please. Andrew Corral, if you would work your way to that second chair, please. Can I have your name and date of birth, please?
Crystal Harvey, July 4, 1991.
Thank you, Ms. Harvey. You are here on an arrest warrant issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. The allegations in that direct complaint are 2 counts of aggravated driving under the influence, both class 4 felonies, both alleged to have been committed April 23rd of 2024. I have appointed a lawyer to defend you against those allegations. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th, both at 8:30 in the Superior Court downtown. On that direct complaint warrant, you have a $2,000 secured appearance bond. If you post that and you are released from custody, you are ordered not to possess or consume any alcohol or drugs without a valid prescription. And if you are released, you cannot operate a motor vehicle if you don't have a valid driver's license.
Okay.
Do you understand those conditions?
Yes, ma'am.
Okay. Thank you, Ms. Harvey. You can step back and get your paperwork. Michelle Gearing to the podium in the courtroom, please. Cynthia Nichols, if you would please work your way to the second chair. Michelle Gearing. and date of birth, please?
It's Michelle Gearing, 0809-1989.
Thank you, Ms. Gearing. You are here on a probation violation warrant. A petition to revoke your probation was filed alleging that you have violated terms 3 and 5. I have appointed a lawyer to defend you. Your next court hearing will be a revocation arraignment hearing March 19th. It'll be at 8:30 in the Superior Court downtown. On that warrant, you have a $1,500 secured appearance bond. If you post that and you're released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Ms. Gearing. You can step back and get your paperwork. Andrew Corral to the podium in the courtroom, please. Brittany Hosmer, if you would work your way to the second chair. Can I have your name and date of birth, please, sir?
Andrew Corral, 21087.
Thank you, Mr. Corral. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. You have a lawyer assigned to you in that case already. That lawyer will continue to defend you. Your next court hearings will be a new status conference March 18th and then a preliminary hearing March 20th. Both of them will be at 8:30 in the Superior Court downtown. On that warrant, you have a $1,000 secured appearance bond. If you post that and you're released, in addition to getting yourself to your court hearings, you are ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
So I have to pay a bond to get out of jail?
That's right, yes. Any other questions?
And what is that, like 10% or something?
Well, you can use a bonding company. I don't know what a bonding company's specific requirements might be. My general understanding is that most require a minimum of 10% down, so 10% of 1,000 would be 100. If you want to go that route, though, I would say find a list of bonding companies back in the jail and call them and confirm their specific requirements.
Okay.
Okay, anything else?
No.
All right, thank you, sir. You can step back and get your paperwork. Cynthia Nichols to the podium in the courtroom, please. Russell Hall, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Cynthia Nichols, age 2684.
Thank you, Ms. Nichols. You are here on an arrest warrant issued after a direct complaint was filed. A direct complaint is a written document that in this case alleges one new allegation against you. The allegation in that direct complaint is one count of narcotic drug possession. It is a class 4 felony. It is alleged to have been committed December 16th of 2024. I have appointed a lawyer to defend you against that allegation. Your next court hearings in that case will be a status conference March 18th and then a preliminary hearing March 20th. They will both be at 8:30 in the Superior Court downtown. On that direct complaint warrant, you have a $500 secured appearance bond. If you post that and you are released from custody, you're ordered not to possess any drugs without a valid prescription. Do you understand those conditions?
So how much is I could bail out for?
500. If you're in custody on something else, though, and you have a bond on that case, I would not post this bond unless you could post both of them.
Oh,
I don't know if you're being held on bond on another. You are?
yeah.
So if you posted this bond, but you couldn't post that one, you would still be held in that case. So I would say if you're not in a position to be able to post all of the bonds you're being held on, probably don't post any of them.
Okay.
Okay, any other questions? Okay, thank you, Ms. Nichols. You can step back and get your paperwork. Brittany Hosmer to the podium in the courtroom, please. Lance Cree, if I could ask you to work your way to the second chair.
Brittany
Good morning. Can I
Hosmer.
have your name and date of birth, please?
Brittany Hosmer, 9/30/1990.
Did you say 9:30?
Yeah,
Okay,
9/30.
thank you, Ms. Hosmer.
Yeah.
You are here on 3 failure to appear warrants, all of them in misdemeanor cases. The first one is a failure to appear warrant issued by the Casa Grande Justice Court. It looks like the underlying allegation in that case is driving on a suspended license. You are entitled to a court-appointed lawyer on that misdemeanor warrant for purposes of release conditions. That lawyer will be appointed for you by the next judge you see at your next hearing.
Okay.
Your next court hearing on that Casa Grande warrant will be an arraignment hearing March 17th. It will be at 8:30 in the Casa Grande Justice Court. On that warrant, you have a $500 secured appearance bond.
Okay, and I have that.
Okay, the second matter you're here on is a failure to appear warrant issued by the Kyrene Justice Court. That one also on a driving on a suspended license allegation.
Yeah.
The last warrant is a misdemeanor warrant issued by the Ironwood Justice Court. It looks like on a misdemeanor criminal speeding case.
Yeah.
On the Kyrene and Ironwood warrants, you are also entitled to a court-appointed lawyer for purposes of release condition. That lawyer I've appointed for you today. Your next court hearing in those two cases will also be the 17th at 8:30. Those are going to be in the Kyrene and Ironwood courts. On each of those, you have a $50 secured appearance bond. So your total bond to get out of custody is $600. It's all secured appearance. But Ms. Hosmer, I want to point out to you, all of your next court hearing dates are the same date. I think they might also all be at the same time. Yeah, so they are all 3/17 at 8:30, and all three of them are in different courts. So here's the deal. If you do not post that bond, that total bond, and you're in custody, MCSO is going to transport you to one of those. And when you're not in court on the other two, that court will issue a new warrant for your arrest. If you post that bond, I understand you can't be in three places at the same time. So presumably you would post that bond and go to one of these, miss the other two.
Yeah.
In order to avoid that, in your release orders, you have the phone numbers to each of the three courts. I highly encourage you, whether you're in custody or not, to try to reach out to those courts and see if you can get at least two of them to change your court date so that you can go to all three court hearings.
Okay.
If you stay in custody and you're only transported to one, I don't know here right now which one MCSO would take you to, but keep all of your paperwork so that if you cannot get this worked out before the 17th, use the numbers in your paperwork to call whichever courts you don't make it to as soon as you can after, because they will likely have issued a warrant for your arrest.
Okay.
And you can probably work that out with the court instead of having to get arrested on the warrant and come back here.
Yeah.
Okay, so keep your paperwork. That's going to be the most important thing you can do.
Okay, am I released though?
You have a bond. So you have a $600 secured appearance bond. If you post that, you'll get released. If you don't, you'll stay in custody. But either way, remember that all three of your court hearings are the same date and time.
And that means I got to change them.
You're going to have to get two of them changed because you can't go to all three.
Because I can't go three.
Right. If they were all in the same court, you might be able to make it. But they're three different courts, so you won't be able to make all three.
I agree.
Okay. Thank you. You can sit back and get your paperwork. Russell Hall to the podium in the courtroom, please. Kyle Wilford, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Russell Chippenhall, 12/28/1990.
Thank you, Mr. Hall. You are here on two probation violation warrants. In both cases, petitions to revoke your probation allege that you have violated terms 3 and 5. I have appointed a lawyer to defend you in both cases. Your next court hearing will be a revocation arraignment March 19th at 8:30. On both of these warrants, or maybe I should say each, on each of these warrants, you have a $150 secured appearance bond. So your total bond will be $300. It is all secured appearance. If you post that and you're released from custody, you cannot possess any weapons or any drugs without a valid prescription once you're out of custody. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Hall. You can sit back and get your paperwork. Lance Cree to the podium in the courtroom, please. Jesse Wells, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
Lance Cree, 4/11/85.
Thank you, Mr. Cree. You are here on three different matters. The first matter that you're here on is allegations of new charges. Those allegations are 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I have found probable cause to support those new allegations and appointed a lawyer to defend you. Your next court hearing on the new allegations will be a status conference March 18th, and then you'll have a preliminary hearing the 20th. Both of them will be at 8:30 in the Superior Court downtown. The other two matters you're here on are probation violation warrants. In both of those cases, petitions to revoke your probation allege violations of terms 3 and 5. I've appointed a lawyer for you in both of the probation cases. Your next hearing in each of those probation cases will be a revocation arraignment hearing March 19th at 8:30, also downtown. On each of these three cases, you have a $100 secured appearance bond. So your total bond will be $300. It is all secured appearance. If you post that and you're released, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yep.
Okay, thank you, Mr. Cree. You can step back. Kyle Wilford to the podium in the courtroom, please. Thomas Melville, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Kyle Wilford, July 2nd, 95.
Thank you, Mr. Wilford. You are here on an arrest warrant issued after a direct complaint was filed alleging a new allegation against you. The allegation in that direct complaint is 1 count of disorderly conduct involving weapons. It is a Class 6 felony alleged to have been committed September 30th of 2022. I have appointed a lawyer to defend you against that allegation. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. They'll both be at 8:30 in the Superior Court downtown. On that direct complaint warrant, you have a $100 secured appearance bond. If you post that and you're released from custody, you cannot possess any weapons once you're out of custody. Do you understand those conditions? Okay, thank you, Mr. Wilford. You can step back and get your paperwork. Jesse Wells to the podium in the courtroom, please. Tremaine Calvin, if you would work your way to the second chair. Can I have your name and date of birth, please, sir?
Jesse Wells, 1983.
Can I have your full date of birth?
10/08/1983.
Thank you, Mr. Wells. You are here on allegations of new charges. The allegations against you are 1 count of dangerous drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. I have found probable cause to support those allegations and appointed a lawyer to defend you. Your next court hearings will be a status conference March 27th and then a preliminary hearing March 31st. They will both be at 8:30 in the Superior Court downtown. On these allegations, I am releasing you to the supervision of pretrial services. What that means is you will be released from custody. You do not need to post a bond. Once you are out of custody, you will be responsible for getting yourself to both of those next court hearings. You'll also be required to make contact with pretrial services once you get out of custody. With your release order, you're going to get a packet from pretrial. Their contact information will all be in that packet, so please keep both your paperwork and that packet. Also, once you're out of custody, you cannot possess any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you, Mr. Wells. You can step back and get all of your paperwork. Thomas Melville to the podium in the courtroom, please. Gonzalo Gonzalez, if I could ask you to work your way to the second chair. Morning, sir. Can I have your name and date of birth, please?
5/30/1965.
And what's your name?
Thomas Melville.
Thank you, Mr. Melville. You are here on a failure to comply with court terms warrant issued by the South Mountain Justice Court. It looks like the underlying allegation in that case is a misdemeanor driving on a suspended license allegation. Because that is a post-disposition misdemeanor, you're not entitled to a court-appointed lawyer. You still have the right to hire a lawyer if you wish to move forward in that matter. Your next court hearing on that warrant will be an arraignment hearing March 26th. It'll be at 9 o'clock in the morning in the South Mountain Justice Court. I am releasing you on your own recognizance on this warrant, so that means on this warrant you're eligible for release and you're going to be responsible for getting yourself to your next hearing on the 26th in the South Mountain Justice Court. Once you're released from custody, if you are, then you can't operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, Your Honor. I'm here I just got released in Nevada prison.
Okay.
I got 5 more months to do.
In Nevada?
No, and the MSCO came pick me up in Nevada.
Okay.
Flew me back here to take me to Alhambra. So I got.
Are you going into DOC custody?
Yeah.
And so are you telling me that you think you will be incarcerated on the 26th and you won't be able to get yourself to that hearing?
Yes.
Okay. So here's what I'll do, Mr. Melville. I will modify your release conditions. I'll give you a minimum $50 bond. The purpose of that bond is not to saddle you with more financial burden. The purpose of that bond is to get that court hearing entered into the MCS.
Can't my daughter just go pay it?
Well, she could, but the problem is if you're in custody and that bond is posted, you won't be transported to your court hearing and you're going to pick up new failure to appear warrants.
I don't understand. So I'll have to stay here until the 26th?
Well, you're telling me that you're going to be in custody anyway, right?
Yeah.
So if I release you on your own recognizance on this warrant, that court hearing doesn't go into anybody's system and your court hearing will come and go and nobody's going to take you to that. You're just going to stay in your cell and that court's going to issue a new warrant for your arrest. So if I put a bond on this, your court hearing date will move up to the 17th and MCSO will transport you so you can go to South Mountain and get that resolved while you're still in custody.
I guess. When I got released, I got a bunch of medications because I got prostate cancer.
Okay.
So, and they won't give it to me here. So,
well, they won't give it to you here at this facility,
yeah.
but that's because this is a temporary facility.
Yeah.
It's just a transfer facility. So if you stay in custody, you'll be transferred to a different facility that's a more permanent facility meant to house people. At that facility, there will be medical services, and you can talk to medical there to get all of your medical needs taken care of.
Okay, and there's no way for my daughter to go pay it?
Well, she can. So your daughter can pay that bond, but you're not going to be released from custody because you're telling me you're in custody on something else.
Yeah.
So posting that bond does you no good because you're going to stay in custody, and the only effect of that bond being posted will be that you miss your court hearing because MCS is not going to know.
I understand now.
Okay.
Thank you.
All right. So like I said, when you go to court it's now the 17th. So when I put that bond, your court date's going to bump up to March 17th. When you go to court on the 17th, tell that judge that you have a nominal bond on this case. That judge can get rid of the bond because, like I said, the purpose of this bond isn't to ensure that you have to pay it. It's to make sure you make it to court.
Yeah.
So when you go to that court can eliminate this bond and just put this case back on track so you don't ever have to pay it.
Okay. Because the only reason why I missed it because I was in prison.
Got it. Okay. Yeah.
For 6 years. Thanks for explaining that.
Yes. Okay. One more thing I need to tell you. When I put that bond on there, that means that you're now entitled to a court-appointed lawyer for purposes of that bond issue. So if you have additional questions about why I'm imposing the bond or how that works going forward, when you go to that court hearing, there will be a lawyer present. That lawyer is not going to defend you in the underlying case, but will work with you to get that bond eliminated. So if, like I said, if you have additional questions or you want more information about moving forward, what's going to happen with this misdemeanor case, talk to that lawyer that's appointed for the bond issue.
Okay.
Okay. I'll get that paperwork reprinted. It's all modified, so we're going to get it reprinted. We'll get a copy out to you. You can go ahead and take a step back to your
Thank you.
Thank you, Mr. Melville. Tremaine Calvin to the podium in the courtroom, please. Oh, I'm sorry, Joe Johns, if you would work your way to the second chair. Come on in. Okay, can I have your name and date of birth?
Tremaine Calvin, May 28, 2000.
Thank you, Mr. Calvin. You are here on a failure to appear warrant issued by the White Tank Justice Court. The underlying allegation in that case is a misdemeanor driving on a suspended license allegation. Because it is a misdemeanor allegation, you're not entitled to a court-appointed lawyer. You do have the right to hire a lawyer to defend you in that case if you wish to have a lawyer present. Your next court hearing on that warrant will be an arraignment hearing April 1st. It will be at 9:30 in the morning in the White Tank Justice Court. I am releasing you on your own recognizance on that warrant, so you will be responsible for getting yourself to your court hearing April 1st at 9:30. Once you are out of custody, you are ordered not to operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, Your Honor.
Okay, thank you, Mr. Calvin. You can step back and get your paperwork. Gonzalo Gonzalez to the podium in the courtroom, please. Can I have your name and date of birth, please, sir?
Gonzalo Lincoln Road, Gonzalez, 06-17-1985.
Thank you very much, Mr. Gonzalez. You are here on a failure to comply with court terms warrant issued by the Country Meadows Justice Court. It looks like the underlying allegation in that case is a misdemeanor assault allegation. Because it is a post-disposition misdemeanor, you're not entitled to a court-appointed lawyer. If you wish to have a lawyer continue or represent you in that case, you do have the right to hire a lawyer to defend you. Your next court hearing on that warrant will be an arraignment hearing March 27th. It'll be at 8:30 in the Country Meadows Justice Court. I am releasing you on your own recognizance on that warrant. That means that you will be responsible for getting yourself to your court hearing on March 27th at 8:30. Do you anticipate any problems with being able to get yourself to court on that day?
No, I'm incarcerated. I'm incarcerated till June 20th.
So yes, so you will not be able to get yourself there voluntarily.
No, just here, come Maricopa.
Okay, so same thing that I did with Mr. Melville. I'm not that I think that you were expected to listen to all of that, but Because you're going to be in custody, if I don't put a bond on this case, you won't be transported to your court hearings and you'll pick up new warrants.
Okay.
So I'm going to put a small $50 secured appearance bond on this warrant. The purpose of that bond is not to saddle you with more financial burden. It's to make sure that MCSO takes you to your court hearing.
Okay.
So I'm going to put a $50 bond on this. That means that court hearing will go into MCSO's system. They will take you to that court hearing. At that hearing, if you want that bond eliminated, talk to the judge about it on that day. Because like I said, the purpose of that is just to make sure that you make it to court. It's not necessarily to make sure that you pay that amount.
Okay.
So when you get to court, talk to the judge about the bond and try and get this case all put back on track so you can deal with it while you're incarcerated. So when your term of incarceration is done, you don't still have to deal with this case.
Okay.
Two things that are going to change when I put that small bond on. The first thing is your court date's going to move up. So now your court hearing is going to be March 17th at 8:30. So on the 17th at 8:30, MCSO will take you to the Country Meadows Justice Court to see the judge on this warrant. The other thing that's going to change is you're going to be entitled to a court-appointed lawyer for that bond issue. So when you go to court, you'll have a lawyer present. That lawyer's role is only to explain to you and work with the court why there's a bond and potentially get it removed.
Okay.
Okay. Anything else we need to address or any questions?
No, ma'am.
Okay. Thank you very much. I'm going to get your order modified, reprinted. We'll bring it out to you if you'll step back to your
Thank
line. I wish these people would tell us if they were incarcerated.
Yeah.
I don't know who these people are, but
I guess we could. So we don't.
sometimes there's a note in there that says like serving in DOC custody. Sometimes there's not, and all I know is it's a page
For the
2.
board card, it'll say help, but we don't really tell you guys unless you guys want us to.
It'd be faster.
If anything,
Okay.
fine.
Okay. Is that one good?
Yeah.
Okay.
But we can even tell you if they have Yeah.
Well, I know that they're page 2s, but sometimes, well, let me finish this. We can talk about it later. Joe Johns, if you'll work your way into the courtroom. Okay, good morning, sir. Can I have your name and date of birth, please?
Joe Johns, August 19, 1994.
Okay, thank you very much, Mr. Johns. All right, Mr. Johns, you are here on a failure to appear warrant issued by the state of Texas. Because you are here on an out-of-state warrant, your hearing's going to look a little bit different than everybody else that has already gone. Before you were put on a court calendar here in Arizona, Arizona confirmed with Texas that is a valid warrant. Texas has indicated that they are willing to extradite you, which means they want to come to Arizona and take you back to Texas. Because of all that, you will have to make a choice at this hearing. So I'm going to explain to you what I think the two choices are. Hopefully it matches the information that you got on that card. Then I will give you an opportunity to ask any questions that you might have about your two options. And then the last thing I'll do is ask you which option you pick. Okay, I know you got it because I saw it in your hand, but did you read the information on that big card?
Yes, ma'am.
Okay. As I indicated, you will have to make a choice on this Texas warrant. So there are two options. The first option you can choose is to waive your right to an extradition hearing here in Arizona and agree that Texas can come and take you back. If you pick that option, first and foremost, you're not waiving any defenses or rights that you have to the Texas criminal proceedings. You are only waiving your right to an extradition hearing here in Arizona, and you're in essence agreeing to go back to Texas. If you pick that option, you will be held in custody here in Maricopa County for up to 30 days without bond in order to allow Texas to come get you. If you pick that option, that 30-day time period will start ticking tomorrow unless you have unresolved criminal charges pending anywhere in Arizona. If you do, then that 30-day time period will not start ticking until the local charges are resolved. So option one is waive your right to an extradition hearing, agree to go back to Texas, stay in custody without bond for up to 30 days. The second option you can choose from is not to waive your right to an extradition hearing. If you pick that second option, I will set an extradition hearing for March 24th at 1:30 in the afternoon. Extradition proceedings in Arizona are civil proceedings, not criminal proceedings. So that means I cannot appoint a lawyer to defend you in the extradition proceedings, but you do have the right, if you pick option 2 and I set that hearing, to hire a lawyer to be present in those proceedings if you wish. If you pick the second option and I set that hearing, governor's warrants are sought by both Arizona and Texas. Once those governor's warrants are signed by both states, that's what allows Texas to come to Arizona and requires Arizona to release you to go back to Texas. The process of getting governor's warrants signed could take up to 90 days. If you pick that second option in that 90-day time period, you are bond eligible on the Texas warrant. It looks like the Texas court has set your bond at $50,000 secured appearance. So if you pick option 2, you are bond eligible, and if you post that bond, you would be eligible for release from custody, but you'd be required to stay in Arizona and then attend all of your extradition proceedings. If you picked option 2 and you did not or could not post that bond, then you would stay in custody while your extradition proceedings are taking place until governor's warrants are signed. Do you understand the 2 options?
So for number 2, I would have to pay the $5,000 bond.
It's $50,000. You could use a bonding company. You would probably be looking at about $5,000 out of pocket. A bonding company might require other terms, but absent whatever the terms of a bonding company are, the answer is yes. You could post that bond and be eligible for release.
Can I state something?
Did you say, can I say something?
May I state something?
You can. I would just encourage you to proceed cautiously because you don't have a lawyer, and both Texas and Arizona could use anything you say against you.
Okay. When do I get a chance to call my people to contact my lawyer?
Do you mean an Arizona lawyer or your lawyer in Texas? Well, it doesn't matter. Either way, the answer is as soon as you can use any of the phones in the facility to contact whoever you choose.
Okay, but my phone is in my phone has my lawyer in it.
And you don't have your phone because it was impounded when you were booked in?
Yeah.
So you'd have to talk to MCSO about that. I don't know what the protocol is for if and when you get access to that. So that's not something I can help you with. I don't know what their policies are on that.
Okay, I'll go with the second option.
Okay. You would like to have an extradition hearing? Okay, then I will set that hearing for March 24th at 1:30 in the afternoon. You will have a $50,000 secured appearance bond. Please remember, Mr. Johns, if you post that bond, you have to stay in Arizona. So please don't post that and then take yourself back to Texas, but nothing stops you from posting that, being released, and working with your Texas lawyer to try to resolve this from Arizona. Okay, any final questions?
No.
All right. Thank you very much, Mr. Johns. We're printing your paperwork now. We'll bring it out to you if you'll step back to your left. Okay, number 1 on the calendar, Vanessa Martinez, date of birth 11/10/1980, is not in the courtroom because she poses a danger to herself. She is here on 2 different matters. The first is allegations of new charges. Those allegations are 1 count of narcotic drug possession, a Class 4 felony, and 1 count of criminal trespassing, a Class 1 misdemeanor. I have found probable cause to support the new allegations and appointed a lawyer to defend her. Her next court hearings on those new allegations will be a status conference March 27th and a preliminary hearing March 31st. The second matter she's here on is a failure to comply with court terms warrant issued by the Agua Fria Justice Court on a misdemeanor driving on a suspended license allegation. Because that's a misdemeanor allegation, she's not entitled to a court-appointed lawyer. Her next hearing will be an arraignment hearing March 31st at 10:30 in the Agua Fria Justice Court. On both of these cases, I am releasing her on her own recognizance. If anything changes after I visit her cell site, I will come back in and update this recording. Otherwise, this court will stand in recess until 11 a.m.
Morning, folks. Who do we have as defense counsel today?
Yes. Good work. Jimmy Zarzicki from the Public Defender's Office, Your Honor.
Can you repeat your name? I'm sorry, it cut out.
Sorry, Jeremy Zarzicki.
Zarzicki?
Yep.
Okay, thank you, sir. And do we have Mr. Terrace today for the state?
Yes, Your Honor. Good morning. Just until Mr. Poston's back from court.
Okay, thanks. And then with the jail, do we have any updates on folks who are not wanting to appear today?
The only update, Your Honor, is Mr. Yuko PCO.
Okay. All right, we'll order continuing. If message can get to him though that because I think we have someone in the gallery who's been coming to court wanting to get resolution on the case. Eventually, at some point, and no later than tomorrow morning, he's going to be forced to come to court if he doesn't appear. So unless he's hot. Oh, okay. So there's an extenuating. I'm being told there's an extenuating circumstance why he can't appear. Is that correct?
There is, Your Honor.
Okay. I'm not entirely clear as to what that is, but I'll hold off for now. So we'll continue his matter. Sir, in the back of the gallery, I'm not exactly clear why I can't disclose or indicate we are live streaming right now. So there may be a personal or private medical reason, for example, he can't appear. That's as much information as I can provide right now. So if you have any way of contacting him while he's incarcerated, if you don't, but otherwise, I just can't give you any additional information. I know you've been showing up. I appreciate you trying to be supportive. So that's about as all. But we're not going to proceed with his hearing today. Yeah, I would say do that. And this is also live streamed as well on YouTube. If you just want to observe what's happening, you don't want to have any direct input. Are you a stated victim in the matter? So you could always watch on YouTube. If you go to the Justice Court website, there's a link that you can find to watch on YouTube instead. So you don't actually have to come into court to do it, if that helps. Okay, thank you, sir. You're welcome. Otherwise, I think we've got everybody. If the jail's ready, we can start taking folks. To clarify for the, if we have an interpreter present, I don't see any Spanish speakers, so you are free to go at this time. Thank you.
Mr. Ray will be first, Your Honor.
Thank you. And I'm showing a DOC hold on Mr. Ray, is that correct? Okay, good morning, sir. We're here today for an initial appearance. Can you identify yourself first and last name?
Andrea.
Mr. Ray, you're here today. Looks like a warrant was issued back in February 2025 for a prior offense of disorderly conduct. This is a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. To the jail, let me just confirm, do we have a DOC hold on Mr. Ray?
Correct, Your Honor.
Okay, so Mr. Ray, what that means is that the Department of Corrections has placed a hold on your case such that even if the court was inclined to release you on today's date, I can't do that at this time, or even if I did, you'd still be held. So what the court is doing in this case is setting a nominal bond of $250 cash or secured. But again, even if you post that bond, you will not be able to be released until the DOC hold is lifted. The court is going to affirm prior release conditions as to the disorderly conduct charged. And you are being appointed counsel because you're going to remain incarcerated. That's going to be John Illis, and he'll be able to get in contact with you. You have a hearing set this afternoon at 1:00 p.m. for a case management conference. So ideally, Mr. Illis will get in contact with you as soon as possible, speak with you about your case management conference. This hearing is set in order to resolve the disorderly conduct charge that arose from several years ago. A lot of information, sir. Do you have any questions at this time?
No.
Okay, you're excused. Thank you very much.
Thank you.
Okay, good morning, sir. Can you state your first and last name?
Good morning, Hector Rios.
Mr. Rios, we have you here today on, looks like there were some prior proceedings. There was a petition for a criminal restitution order that was filed and granted back in October of 2023. So my understanding is that you've been picked up for failure to appear as to revocation of probation. And the underlying offenses that we're discussing are misdemeanor offenses. You do have a right to remain silent. Anything you say will be used against you. The assigned judge in this matter has requested that bond be set in this matter in order to assure your appearance on the information available to the court. The court approves that request. The court is setting bond in this matter at the requested amount of $2,499 cash bond. And the court will further affirm prior release conditions. You have your next court date to resolve this whole matter is on March 26, 2025, 1:30 p.m. at the Tucson City Court, and that's with Judge Million. And once you appear at that hearing, you should hopefully be able to resolve the pending matters before the court. Do you have any questions at this time?
Okay, no questions.
You're excused. Thank you, sir.
All right. So I have to pay what? Or $250 with the liable. $250 with the liable. How do I get a hold of my people to do that?
Sorry, what was that?
Where do I go talk to the jail? Who do I talk to? I told them this right out. How much do I have to pay? You gotta, it's the bond is $24.99. Okay. $24.99? Yeah. How much would I have to give though? If you go through a bail box, it's $250 plus collateral. $250 plus collateral. What's collateral? Like a card. Okay. All right, thank you. Specialist. Yeah, give me a sec. All right, folks, everything on the side. All around your person. Check. First, okay.
Sounds good. Thanks. Okay. Good morning, ma'am. Can you state your name, please?
Good morning, Guadalupe Dicochea.
Ms. Dicochea, we have you here today on a few misdemeanor charges for assault, disorderly conduct, and criminal damage. You do have a right to remain silent. Anything you say will be used against you. In review of the information before the court, at this time, the court is going to order that you be released on your promise to appear at future proceedings, but there are going to be several conditions of release. No drugs or alcohol, no acts of domestic violence, no firearms or weapons to be possessed by you. No contact with the victim, Arthur Niemer. You're not to go to his residence or workplace. The court is going to set your next hearing as an arraignment on these charges at the Sahuarita Municipal Court, April 1st, 2025, 8:30 a.m. That's April 1st at 8:30 at the Municipal Court, Sahuarita. If you do not appear, a warrant could be issued for your arrest, so do make sure that you appear. Any questions at this time before you're released?
No.
Okay, then you're excused. Thank you, ma'am.
Thank you.
Mr. Wood?
Good morning, sir. Can you state your name, please?
Good
morning. Key John Woods.
Thank you, Mr. Wood. We've got a couple of matters for you today, so we'll take them one at a time. Just give me one moment to get your files up. Let me just double check. Do we have, it looks like we may have a Superior Court hold on Mr. Woods. Is that correct, Jail?
Correct, Your Honor.
Okay. So in general, Mr. Woods, you're here today on a couple of failures to appear. There was a minor possession of alcohol charge. In addition, there was a charge for, get the other one up, criminal damage. In general, you do have a right to remain silent as to these pending matters. Anything you say can and will be used against you. The Superior Court has placed a hold prohibiting you from being released at this time. So even if the court was inclined to release you on today's day, I wouldn't necessarily be able to do it. What the court is going to go ahead and do is set nominal bond in this matter in the $100 in the amount of $100 cash is secured. That'll be consecutive in each matter. So total bond of $200 required. Until that hold is posted or is resolved with the Superior Court, the court's unable to release you at this time, and so the court is going to appoint counsel for you since you don't have, since you are being held at this time. Let me just, it's going to be Gary Brinkowicz is going to be appointed to represent you on today's date. Court's going to go ahead and affirm prior release conditions, and so your next court dates in this matter for these failures to appear, that's going to be on March 13, 2025, 1:00 p.m. So that'll be tomorrow, 1:00, with Judge Ball at the Justice Court. So that'll be your first opportunity to get these charges resolved. But again, even if they're resolved and you're able to be released, there's still that hold that needs to get resolved. And I don't have a lot of information on that right now, so I can't really address that with you more fully. In any event, do you have any questions, sir, at this time?
No, I do not.
Okay, so then you are all, I believe you're all set. You can be excused. Thank you, sir. Okay, just one moment, ma'am. Almost ready to go. Okay, sorry about the delay, ma'am. Would you please state your first and last name?
Jacqueline Bell.
So we have you here today on. Looks like a failure to appear for a prior charge of theft. It looks like there was a warrant that was issued on or around August 7, 2024. Case has been open since approximately 2022. So you do have a right to remain silent. Anything you say can and will be used against you. In order to ensure your appearance at future proceedings, the court is going to set bond in the amount of $500 cash or secured, and any prior release conditions are affirmed. You do have your next court date in this matter, March 21st, 2025, 1:45 p.m. for video review with Judge Mayhew at the City Court. If you do post bond and you're released after posting bond, you still need to go to that video review hearing at the City Court, March 21st, 2025. Any questions at this time?
Yeah, I understand that the warrant was for $250. So would the bond be higher than the actual warrant?
Let me double check. I'm not sure if I have warrant information at this time. Oh, here we go, right here.
If she was released.
Do I have to? I can set then date.
The video release,
Yeah.
if she released, she can come in and drop it. That's written. Is there an update there? Or is it the same?
Sorry, just one moment. We're just trying to figure out the setting that there is an outdate here. Yeah.
Yeah.
Okay, do you want me to indicate that as well?
Yeah, just that she's released, that she can come in on her.
Okay, so the court at request of the defendant, the court will reduce bond to be indicated. The court will set bond at $250 cash or security. And so there are a couple of dates that you have then under the circumstances, Ms. Bell. We have the video review if you're still incarcerated, March 21st, 2025, 1:45 p.m. However, if you do postpone and you're released before then, you can also, in the alternative, go to your April 16, 2025, 2:00 p.m. hearing. And that's also at the city court. So you have a couple of dates. If you do get released before the video review, you can go to the April 16, 2025, 2:00 p.m. date. The court will appoint the city public defender's office to represent you in this matter. Did you want me to restate anything or did you have any questions, ma'am?
No, I suppose I could talk to your staff here on how I could pay the $250 bond from inside here, so I don't have any further questions. Thank you, Your Honor.
Okay, thank you. You're excused, ma'am.
Brian Guthrie.
Good morning, sir. Can you state your name, please?
Brian Christopher Guthrie.
Is we show that there is a different name listed. Do you go by any other names?
No.
So what is your legal first name?
Ryan, R-Y-A-N.
Okay, that just want to make sure we've got the same individual. So Mr. Guthrie, then you are here today on account of disorderly conduct, a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. Does not appear that pretrial services was able to contact the alleged victim in this matter without that input. At this time, what the court's going to go ahead and do is as follows. The court is going to order that you be released on your promise to appear at future proceedings. However, the court is going to order that you not have any contact with the victim, Amanda Metz. You're not to go to her residence or workplace. If you do happen to share that residence with Ms. Metz, the court is going to order that you are permitted to return one time with law enforcement to retrieve your belongings. The court is going to set your next court date as April 8th, 2025, 1:30 p.m. at the city court. And that will be with Judge Millian to have your next hearing on these charges or this charge. Make sure that you go to your future court date. Failure to appear can result in a warrant being issued for your arrest. Did you have any questions, sir, at this time?
No, sir.
Okay, then you're excused. Thank you.
Silva, E.
Good morning, sir. Can you state your name, please?
E. Silva.
Mr. Silva, we've got you here today on some failure to appear for some charges in 2024, criminal trespass, drug paraphernalia, theft, and also another drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You have working transportation at this time?
Yes.
And so if the court set a court date for you to attend, are you able to appear at that court date?
Yes, sir.
And then, so if the court gave you an opportunity to do that in lieu of holding you, would you promise to appear at future proceedings?
Yes, sir.
All right. So the court at this time is going to order the defendant be released on his promise to appear at future dates. The court is going to order that there not be any possession or use of alcoholic beverages or illegal drugs as a condition of release. And any prior release conditions are also affirmed. Next court date in this matter will be a pretrial hearing that's set April 14, 2025, April 14, 2025, 2:30 p.m. And that'll be with Judge Cranshaw at City Court. Judge Cranshaw already issued a warrant for failure to appear, so I don't think that he'll hesitate to do it again, Mr. Silva. Do make sure that you appear April 14, 2025 at that hearing. Okay, sir?
Yes, sir.
All right, you're excused.
Valenzuela Rodriguez.
Okay, good morning, ma'am. Can you state your name, please?
Joanna Valenzuela.
Okay, do you go by Joanna Valenzuela Rodriguez?
Yeah.
Okay.
Yes.
So, ma'am, you're here today on a few misdemeanor charges for endangerment, assault, and disorderly conduct. You do have a right to remain silent. Anything you say can and will be used against you. In review of the matter and the information before the court is going to enter the following orders as to your case. The court is going to order that you be released on your promise to appear in future proceedings. There are several conditions of release. These are fairly detailed, so I'm just going to review them slowly with you. You're not to possess or consume any alcohol or illegal beverages until further court order. Commit no acts of domestic violence, and also not to possess any firearms or weapons. And this is where it gets a little bit detailed, so I'm going to, if you need me to repeat this, let me know. You're not to have any contact with the individual Christian Anaya, except through a third party to coordinate contact with your child in common. Additionally, you're not to go to Mr. Anaya's residence or workplace unless it's part of an exchange of the child in common, but you're not to have any contact with Mr. Anaya within 10 feet, not to go within 10 feet of him until further court order. And if you do share this residence with Mr. Anaya, then you can return one time with law enforcement to get your belongings. Do you have any questions about those release conditions?
No, sir.
Okay. In that case, then we'll set your next hearing in this matter, April 8th, 2025, 1:30 p.m. with Judge Millian at the Tucson City Court. Make sure that you appear at future hearings. Failure to appear can result in a warrant being issued. Do you have any questions?
No, sir.
Then you're all set. Thank you, ma'am.
Thank you.
Luis?
Oh, let me, before we proceed with Mr. Ruiz, Mr. Silva, I believe, did we have a hold on him?
We did, Your Honor, Superior Court hold.
Oh, okay. So if we can bring him back, ideally after we get him back after Mr. Ruiz, then we'll have to inform him about that. Thank you. Okay, so Mr. Ruiz, can you please identify yourself first and last name? So, Mr. Ruiz, we have you here today for a failure to appear. It looks like it's sentencing on some cases in 2024 for possession of prescription drugs and drug paraphernalia. So you do have a right to remain silent. Anything you say can and will be used against you. In order to secure your appearance at future proceedings, the court will set bond in this matter, $250 cash or secured. Court will appoint the city public defender's office to represent you, and also any prior release conditions will be affirmed. Your next court date in this matter will be on March 21st, 2025 at 1:45 p.m. And that'll be with Judge Maldonado over at City Court. And so if you do end up posting bond, and this is where we could do an outdate if he does post. If you end up posting bond before your video review on March 21st, you would have an alternative court date, which would be April 10, 2025 at 9:30 a.m. If you are still incarcerated at the time of the video review, however, you would be presented for that, made available for that at the city court. Do you have any questions, sir, at this time?
No.
Okay, then you're excused. Thank you, sir.
Your Honor, Mr. Silva went to the bathroom.
Okay. So we just bring it back maybe before we start with the felony cases. Before we can maybe do Mr. Sanchez, but after that, bring him in.
That's fine, Your Honor. Let me get Mr. Sanchez and we can still see Silva.
Okay. Or if you want to wait, I know we have to do Mr. Sanchez separate. Do you want to just wait for him to finish and bring in Mr. Silva?
Don't know how long they'll be, sir. It's probably more efficient to do Sanchez.
Okay, let's do that.
Thank you.
Yes, please.
Sanchez.
Okay, good morning, sir. Can you state your name, please?
David Lewis Sanchez. Good morning, Your Honor.
Mr. Sanchez, we have you here today. And do we have anybody else in the room?
No.
No, Your Honor. No, the defendants. Okay, so Mr. Sanchez, you're and Mr. Zarzicki, do you want me to waive reading on this, or what would you like?
Yeah, that's fine.
Okay, Mr. Sanchez, you're here on two Class 2 felony counts Your defense counsel has waived reading as to the actual charges. If you need to review those charges before we finish today, you're welcome to confer with counsel about that. As to the pending charges before you, we have bond being requested by the state in the amount of $180,000 with release to pretrial services if bond is posted. Mr. Terrace, any additional record?
No.
Okay. And then Mr. Zarzicki, any record on behalf of the defendant?
Yeah, Judge, obviously this is a hard case given the nature of the charges. I will note that largely, at least based on the what we have so far, largely the state's case is based on the statement of the victim. Basically, that's the entirety of the case. Not here to litigate the nature of it, but needless to say, it might not be as severe as the interim complaint would indicate. Bottom line, as far as his background goes, I mean, he has no prior as part of this. He's, with but for the nature of the charges, he's a level 1 offender. He does have some history of mental health and substance abuse issues. Given his age, Your Honor, I do strongly suspect that mental health issues might be exacerbating, as they tend to with people in their early 20s. I would obviously, if the court is willing to entertain a release to pretrial services, we would happily, and he would happily abide by any conditions that the court wants to impose. Barring that, we would ask for a more reasonable bond amount. The $180,000 suggested by the state is akin to a no bond. We'd ask for something more than $50,000.
Okay. At this time, the court will step on in this matter the amount of $50,000 cash is secured with release to pretrial services if bond is posted. Additionally, the court will enter the following conditions of release. And the court will just indicate part of the reduction of bond is in part because even though there is a victim in this matter, this is a severe charge, that it doesn't appear that there is a set of victims or more than one victim, which does, I think, reduce the danger that the defendant poses, but there's still danger that is posed to the community that necessitates a bond being set in this matter. Conditions of release if bond is posted to follow because they'll be released to pretrial services, monitoring and treatment as directed by pretrial services. Additionally, that the defendant is not to have any contact with the alleged victims. If there's a shared residence with the victim, may return with a police escort to pick up belongings on one occasion. And additionally, the defendant shall not go to the victim's residence or workplace. As an additional condition of release, no contact with any children until further court order. The counsel is appointed in this matter, Pima County Public Defender's Office. Next hearing date for Mr. Sanchez, March 24th, 2025, 1:30 p.m. That is for preliminary hearing at the Justice Court. Mr. Sanchez, if you are still incarcerated at time of future hearings, you'll be made available. But otherwise, if you are released and do post bond, you need to make sure to go to future hearings. Failure to appear can result in a warrant being issued. Any questions at this time?
No.
Okay, then you're excused. Thank you, sir.
Your Honor, if I may, good morning. This is Spanish court interpreter. Just making sure there's no Spanish speakers.
I think we're all good. You can be excused.
Thank you so much. Have a great day. Bye-bye.
This is Mr. Silva.
Hi, Mr. Silva. Welcome back. Sorry for the mix-up. So the court observed that you have what's called a superior court hold, which means that even if we tried to release you on today's date, they wouldn't actually let you out. So I don't know why there's a hold. I don't have that information right now, but because there is that hold, and the court wants to at least try to give you some an opportunity to get any sort of necessary time credit on anything that's pending right now. The court is instead going to set bond in this matter as to all pending charges in the amount of $50 cash is secured. And the court will appoint the City Public Defender's Office to represent you. Once that hold is lifted by Superior Court, you should be able to post bond and be released, but just confer with your public defender more fully about that. So we had to just inform you that that's what's going to happen. That's why we had to bring you back today. The court will set a video review in this matter March 21st, 2025, 1:45 p.m. with Judge Cranshaw to check in on things. So with those adjustments, any questions, Mr. Silva, at this time?
No.
Okay, then you're excused. Thank you, sir. Thanks.
Middle? Are we ready to see? Way down, way down. Say more, please. It's called here.
Good morning, ma'am. Can you state your name, please?
Valdiera.
Valdiera, you're here today on a couple of felony charges: possession of a narcotic drug, possession of drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and there is counsel seated next to you to assist you. The state is recommending bond be set in the amount of $7,500 with release to pretrial services if bond is posted, and that this is also in lieu of requesting no bond. Any additional record, Mr. Terrace?
Judge, the state would like to amend the recommendation to release to pretrial services.
Okay, and then Mr. Zarzicki, any objection to that?
Obviously not. I appreciate it.
Okay, in that case then, Ms. Baltiera, it looks like the state is giving you a gift today. They're not requesting that bond be set. They're going to order, they're recommending that she be released to pretrial services. The court's inclined to go ahead and do that then. If that's their recommendation. So you are going to be released on today's date to the third-party supervision of pretrial services. You need to make sure that you follow up with pretrial services as soon as possible. That's a way that we see people often fail when they're released, is if they fail to check in with pretrial services, and then a warrant's issued for failure to apply. So make sure that you check up with them. You'll get their information before you leave today. You're not to consume or possess any alcohol or illegal drugs. Court will appoint the Pima County Public Defender's Office to represent you as well. And so then your next court date then is going to be April 1st, 2025, 1:30 p.m. for a preliminary hearing at Justice Court. Since you're being released today, that hearing may be moved. And so just check with your public defender about when that next hearing is going to be set in your case, okay?
Yes, sir.
Any questions at this time?
No, sir.
Okay, then you're excused. Thank you very much.
Thank you. Thank you.
Escenas.
Okay, good morning, sir. Can you state your name, please?
Juan Carlos Becerra.
Mr. Becerra, you're here today on, let's see, a couple of matters. We'll take them one at a time. First matter we're here for today is for felony charge of theft of a firearm. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There is counsel seated next to you to assist you. State is requesting bond be set in the amount of $2,500 with release to pretrial services if bond is posted. Mr. Terrace, any additional record?
Your Honor, the state is going to keep the recommendation. I will just note that in the recommendation, it says that the defendant is facing mandatory prison time if convicted. And the state would like to correct that and say that he is not. He would be probation available at trial.
Okay, thank you. And then Mr. Zarzicki, any record?
Yeah, I want to make a record on a couple things. First off, as to the probable cause of this, and I understand this is probably more a trial or more directly a pre-trial issue, but I do think there's some weakness in the state's statement. So he was discovered in a vehicle. So first off, he was discovered in a vehicle. The gun was then discovered pursuant to a quote-unquote Terry frisk of the vehicle, which is not a thing. That's not legal. There is no such thing as a Terry frisk of a vehicle. But additionally, the gun was discovered under the seat. He denied any knowledge of it. It was never in his actual physical possession. There's obviously no forensics to tie it to him, etc. So I do want to point out some of the weakness in the state's case. Regardless of whether or not that's enough to establish probable cause, I think it does go to the limited culpability here. Mr. Becerra is a full-time college student, lifelong resident. He has confirmed residence with his mother. He has absolutely no priors. He's a level 1 suspect, nonviolent felony. we would ask for release from trial services.
Any additional record, Mr. Terrace?
No, Your Honor.
Okay. As to the theft of a firearm charge, the court is going to order releasing the defendant to the third-party supervision of pretrial services over the objection of the state. Court will order as conditions of release, no possession of firearms or weapons by Mr. Becerra. Any firearms in your possession shall be surrendered to law enforcement. Follow monitoring or treatment as directed by pretrial services. Court will order that the Pima County Public Defender's Office is appointed. If not already stated in my signing off on the complaint, the court will find, however, probable cause to proceed on this current charge. And Mr. Becerra, if your appointed counsel may be able to make something happen with that at a future hearing date, but the court is going to go ahead and preserve the charge for the time being, based upon the information before the court. Since you are being released as discharged, preliminary hearing is set April 1st, 2025, 1:30 p.m. That hearing date may be moved. That would have been at the Justice Court. That hearing date may be moved because you're being released on this. So check in with your public defender about your next court dates to make sure you don't miss a court date. A warrant can issue for your arrest if you fail to appear at future court dates. So that is the first thing we have to see you for today. Second matter is some additional charges regarding, give me one moment, reckless driving, having a concealed weapon without a permit, and failing to admit carrying a deadly weapon, which are misdemeanor offenses. You do have a right to remain silent. Anything you say can and will be used against you. And then, Mr. Zarzicki, this is on the misdemeanor. It doesn't technically have right to. Mr. Terrace, do you have any objection if I inquire with Mr. Zarzicki on this, or would you prefer we just proceed without that advice of counsel?
No, Your Honor, no objection.
Mr. Zarzicki, is there anything that you want to say about these charges, just to give you an opportunity?
I would reaffirm, it looks like they probably arrived on the issue, so I would just reaffirm what my stated position before. It does not look like this is anything more serious than what we've already dealt with, and he does have confirmed residence.
And so what the court's going to do then is court will, on these specific charges, the court is going to order Mr. Becerra that you be released on your promise to appear at future proceedings. Your next court date in this matter is March 24th, 8:30 a.m. at the Justice Court for an arraignment. So that's going to happen. That's going to be your first hearing as to your pending charges. There are several conditions of release. You are not to drive without a valid license, no alcohol or illegal drugs. Actually, no, I'm going to take off alcohol or illegal drugs. I don't think there's any mention of use of alcohol or illegal drugs. However, the court is going to affirm no firearms, surrender any firearms, as well as additional conditions. Next court date, March 24th, 8:30 a.m. as your next court date. Do you have any questions at this time, sir? No. Okay, please make sure that you follow up with pretrial services for the felony offense and that you go to future dates. Critically important. Court's giving you a chance here, so don't make the court look foolish, okay?
Yes, Your Honor.
Okay, then you're excused. Thank you, sir.
Thank you. Have a good day.
Defender, you're up.
Can I have a seat? Can I go in person?
No.
Your Honor?
Sit down.
Can I appear in person, please?
Mr. Bender, the court's going to deny your request for an in-person appearance at this time without prejudice.
Can I have the green screen removed so my people are behind me, please?
The court will also deny that request, sir. Go ahead and hold your comments for right now. If you need to confirm with counsel, we'll give you that opportunity. So, Mr. Bender, you're here today on a charge of burglary in the third degree unlawful entry. It's a class 4 felony. You do have a right to remain silent. Anything you say can and will be used against you. And you do have a right to assistance of counsel. And in this matter, the state has a bond recommendation, which is for $5,000 plus release to pretrial services. If bond is posted, Mr. Terrence, any record on that recommendation?
Your Honor,
Mr. Bender, please do not interrupt. Go ahead.
Your Honor, the state is concerned given his lack of ties to Tucson. He does state that he lives in Flo. He is on probation out of that jurisdiction. for a similar offense. He was also charged with burglary 3rd degree in that case.
Thank you. And then Mr. Zarzicki, do you want a moment to speak with the defendant before we proceed?
Yeah, that'd be great, Your Honor. Let me mute this real quick.
Your Honor, please. I don't want to talk to a lawyer anymore. They've screwed me so bad already in the last year or two. I already have ethical concerns with the 2 lawyers up in Globe. It's already been filed on the court that it's ethical concerns. And they were discussing evidence freely on both sides in my private matter with my ex. These lawyers need to get out of my life. I need to just talk to you. That's it. I don't need to talk to the lawyers anymore. You need to leave.
Okay. At this time, the court was going to, Mr. Zarzicki, any record that you want to make?
The one thing I have an inquiry about, Your Honor, is and I don't know if the jail staff might know, is there a hold on him out of Gila County yet? Okay.
I'd request to be transferred up to Globe if you want me to hold out there. But I would like to see Judge Wright. Not the old guy, the younger one with the black hair.
Let me just confirm something really quick, Mr. Bender. Jail, is there a current hold out of another jurisdiction?
You're not showing when you're here.
Okay. Anything else, Mr. Zarzicki, before we proceed?
I'll just note, since he doesn't have a hold out of Gila County, that that is the one reason I'd ask for release, so that he can deal with his probation case. Deal with his stuff here, then go up and deal with his probation case. Assaulted for in court.
I do not have transportation up to my home or a phone. So it's going to be impossible to find my way there. I've tried for 2 or 3 days. My feet are beat to shit. I've been walking like 500 miles, 600 miles in a couple of days just to get home.
So, Mr. Bender, at this time, court will just request respectfully that you hold any additional comments at this time. I'll ask you if you have any questions at the end. The court at this time will order that bond be set in the amount of $1,500 cash and secured with release to pretrial services if bond is posted. Court will further order as conditions of release not to go back to the incident location, not to have any contact with any alleged victims relative to the offense. Court will order the Pima County Public Defender's Office to be appointed to represent Mr. Bender. And then next hearing for Mr. Bender will be a preliminary hearing, March 24th, 2025, 1:30 p.m. at the Justice Court. And then the jail's not showing any holds at all, right?
No, show.
Okay. And then, so Mr. Bender, at this time, do you have any questions before we conclude?
Just how do I get home?
I think part of the benefit of having a public defender appointed is that you can start brainstorming some of those issues with that public defender. They should be reaching out to you shortly as well. So at this point, then.
They did not try 1 second last time either. So no, I don't want a lawyer. I just want to go home. I just want to go home.
So then,
it's like 100 miles from here.
So this time,
take a ride by a cop.
So at this time, the court, okay, go ahead, mute his line, please. Okay, so at this time, Mr. Bender, the court, in recognizing the alleged offenses, the court is setting bond to ensure your appearance and also based upon the alleged offenses. Speak with your public defender. If you don't wish to have counsel after that, I have an obligation to appoint counsel for you. It's a constitutional right that you have, and so that's why the court's doing that today. At this time, the court is going to conclude today's initial appearance. You are excused. Thank you, sir.
You got it.
Okay, good morning, sir. Can you state your name, please?
John David Bowman Jr.
Mr. Bowman Jr., we have a couple of matters we're seeing you for today. We'll take them one at a time. First matter I see that is before us, it looks like it's a couple of warrants that were issued for failure to appear. Let me just pull up something really quick and we'll go ahead and proceed. Okay, so we have a couple of warrants that were issued, sir. There was for a criminal failure to appear in a criminal trespass matter, failure to appear occurring on or around January 2nd, 2024. Then a warrant was issued. Additionally, you were to appear at the Superior Court on updated charges of drug use, dangerous drug use, narcotic possession, 2 counts, and a drug paraphernalia violation. You do have pending felony charges. You do have a right to remain silent. Anything you say can and will be used against you. And the warrant as well was for failure to appear on trespass. So we have a couple of failures to appear that we're trying to address on today's date, and they're in different jurisdiction. One in Superior Court, one in Superior Court. State is recommending, I believe Mr. Terra says, to the failure to appear on the drug offenses in Superior Court that bond be set in the amount of $7,500 plus release of pretrial services. Any additional record?
No, Your Honor.
Okay. Court will note there looks like a 6 and a 6 on the NCA and FTA scales as well, noted by pretrial services. The assessment does indicate prior history of failure to appear despite being provided actual notice of the proceedings. Mr. Zarzicki, any record as to the warrants?
Yeah, I'll just note, Judge, I know given the level 4, 6 and 6 recommendation, the court is probably strongly disinclined to release pretrial services. Obviously, if the court was willing to do so, we would advocate for that. What I will point out, though, however, is there's an arraignment no-show from last month is the only issue in this case. He is a lifelong resident. He only has 1 prior felony case. Both that case and this case were not offenses. If the court is not inclined to release to pretrial services, given his current economic situation, pretty much is going to be condemned lives. But we'd ask for something like the order of 1,500 at least, give him some realistic possibility of posting bonds.
Okay. This time, as to the Superior Court failure to appear, the court is going to order setting bond in the amount of $1,500 cash if secured with release to pretrial services. If bond is posted, condition of release will include to follow monitoring or treatment as directed by pretrial services. Any prior release conditions for these charges are affirmed, and Mr. Bowman is directed, if he is released, to contact pretrial services on the first business day following his release. Pima County Public Defender's Office is appointed to represent Mr. Bowman. There's an arraignment onto these pending these various felony drug charges at the Superior Court. It's going to be March 19, 2025, 1:30 p.m. For an arraignment. Mr. Bowman, if you're still incarcerated at that time, you'll be made available virtually for the arraignment at Superior Court. And then at this time, we'll go ahead and go on to the misdemeanor matter for trespass. Since you are being held as to the other matter, the court is just going to set nominal bond in this matter as well, so you get any time credit as to the pending charges. That will be in the amount of $100 cash or secured. The court will appoint Mr. Gary Grinkwich to represent you on today's date in the misdemeanor trespass matter. Any prior release conditions for that matter are affirmed. And that court date for the Trespass and Justice Court, that is March 13, 2025, 1:00 p.m. for an arraignment with Judge Ball. And so, Mr. Bowman, you'll likely be, you may be incarcerated at time of that hearing tomorrow. Make sure that you appear at all future hearings. Failure to appear can result in a warrant being issued. Do you have any questions, sir, at this time?
No, sir.
Okay, you're excused. Thank you. Oh, you know what? I'm sorry. Let's get it back really quick. We have one more thing to address. Sorry, Mr. Bowman. We had also, there's some city court matters that you are here for. I imagine that's why the warrants came up, is because there were some shoplifting issues that were noted from looks like March 11th. So you do have a couple of misdemeanor charges: theft and drug paraphernalia, shoplifting and drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. At this time, the court is going to, because you're already being held on the other matters, the court will set bond in this matter as to these charges in the amount of $50 cash or secured. Court will order appointing the City Public Defender's Office to represent you. Order that you not go to the incident location relative to the shoplifting offense, and not to also consume any alcohol or illegal drugs. Next court date in this matter is going to be a video review, March 21st, 2025, 1:45 p.m. for video review with Judge Maldonado at the City Court. So that's an additional hearing that you do have for yourself as well. Okay, at this point then, we should be all set. Thank you, Mr. Bowman.
Thank you.
Good morning. Neil Poston for the state.
Okay, thank you, Mr. Poston.
Forgive me, I was in, of all places, Juvie Court doing a restoration rights hearing that I had to be present.
Okay. Thank you for appearing. Mr. Terrence was able to amply compensate. Okay. We'll go ahead and proceed then. Mr. Brown, is that you?
Yes, sir.
You're going to identify yourself first and last name?
Quincy James Brown.
Mr. Brown, you're here today on a couple of matters. We'll take them one at a time. First matter that we'll discuss is we have possession of our narcotic drug for sale of a narcotic drug, and possession of drug paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. And you do have a right to assistance of counsel. There is counsel seated next to you to assist you on today's date. State is recommending bond be set in the amount of $10,000 with release to pretrial services if bond is posted. It appears we also have a DOC hold on you at this time. Is that correct, Jail?
Yes, Your Honor, that's correct.
Okay. And so what that means, Mr. Brown, is even if the court was inclined to release you on today's date, the Department of Corrections has placed a hold on your file essentially so that you would not be able to be released until that's resolved. But the state is recommending $10,000 with release to pretrial services. Any additional record, Mr. Poston?
Your Honor, I do show his our administrator had us do two recommendations. It looks like
I only have one in the court file right now. Is that something maybe you can send over to the initial appearances email?
I did, but I'll send it again.
Okay. Did we happen to have a second? Do we have a second one for them, a second recommendation?
Oh, good. So then we get and then we talk about it.
And
he hasn't given you preference.
I'm sending it presently, Judge.
Okay, we'll wait to get that before we proceed.
I just sent it now.
Thanks. And then, Mr. Zarzicki, do you want to speak with Mr. Brown any further? We've got a little bit of time.
I do.
Oh, okay, it's not coming through. Okay. Yeah.
Did you receive it, Your Honor?
We just got it.
Thank you.
Okay, thank you. Okay, Mr. Zarzicki, let us know when you guys can jump back on.
So here's where we're at, Your Honor. And let me hold on. Just going to pull up the evidence here. I'm reviewing the second recommendation. So I'm not entirely sure why there's a second recommendation on this case. I'm not sure which one you're dealing with.
Mr. Poston, is the second recommendation as to the unlawful flight?
Yes.
Gotcha. Unlawful.
There are two different dates on the felony charges, and this is for the subsequent date.
Understood, Your Honor. All right, so let me address a couple of things then. We have, hold on, let me bring up the so first off, Mr. Brown wanted to make clear that he very much contests the charges on this case. And let me check what the state's alleging as far as the actual basis goes. But essentially, this sounds like, even if we take the state at its word, the worst case scenario in this complaint, this sounds like sort of the typical case where we have somebody that was busted with a large amount of drugs and the state just presumed under the statute sales. He fully contests that he was selling drugs. We won't speak as to the possession on that, but he definitely contests he was selling. As to the parole hold out of Gila County, we would ask that he be released so that EOC can pick him up and can finish out his time. He indicated that if he does indeed, if he can kill his number, he should be done in April anyway, so that he can be released and come back down here and deal with these cases after he's killed his time.
Any additional record on this first set of charges, Mr. Poston?
None.
Okay, at this time, court will is ordered setting bond in this matter, $10,000 cash and secured with release to pretrial services if bond is posted. Additional conditions of release and follow monitoring or treatment is directed by pretrial services, no alcohol or illegal drugs. Go ahead and mute the line, please. Okay, counsel is appointed Pima County Legal Defender's Office to represent the defendant. Next court date is going to be preliminary hearing, March 24th, 2025, 1:30 p.m. at the Pima County Justice Court. So that will be what we do for that one. And then we're going to go to the next issue, and that's going to be the unlawful flight. State has recommended bond be set in the amount of $2,500 plus release to pretrial services and bond that would be consecutive. Any additional record, Mr. Poston?
No, Your Honor.
And now, Mr. Zosik, if you want to go ahead and unmute, any additional record on the unlawful flight?
I'll definitely make a record on that one, Your Honor. He is homeless. He is unemployed. That $10,000 bond is a no bond for all intents and purposes. We don't need to stack $500 on top of it. So we're asking for not release, but either a nominal bond or I don't know if the court can technically order a confirmed bond. I guess since they're both pre-indictment, the court can. So we'd ask for either confirmed bond.
And are these both with the Justice Court? Oh, they are. Okay. Okay. All right. At this time, the court will order setting bond in this matter, $1,000 cash secured. Court is going to, I'm going to leave it as consecutive under the circumstances. Court will order that the defendant not drive without a valid license. Counsel is appointed in this matter. That will be John Illis to represent the defendant. Next court date, March 24th, 2025, 1:30 p.m. for a preliminary hearing. And then, Mr. Brown, make sure that you appear in future proceedings. Failure to appear can result in a warrant being issued for your arrest. And at this time, the defendant is excused. Okay, good morning, sir. State your name, please.
Justin Davis.
Mr. Davis, we've got you here on a couple of matters. We'll take them one at a time. First matter we're here for is a charge of possession of a dangerous drug, possession of paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you state can and will be used against you. You do have a right to assistance of counsel. Counsel is seated next to you to assist you. State is recommending bond be set as to these charges in the amount of $7,500 plus release to pretrial services. And then any additional record, Mr. Poston?
No, Judge.
Mr. Zarzicki?
Judge, I'll note the charges on this case are invalid and relatively. We're talking over 30 existing arrests. Obviously, we are talking about a long period during which he was on warrant status. We're talking about scores here. That being said, though, he is a lifelong Tucson resident. His sister is in town, is verified. His residency offered to provide support and transportation for him. And I mean, not to be glib on this, but he was in warrant status for a long time, and the fact that he wasn't picked up on new charges during that time, it's a bit of an outlier. That kind of indicates that he's probably doing better, all things considered. So given that he has not picked up any charges since he's been in warrant status on this, prior to now, and given the support that he has until we asked the court to consider release pretrial services, barring that
Let me check on something really quick. Just one moment. I know. All right. Okay, so we had a little bit of a mix up, paperwork off in the wrong file, so that's our mistake. So, Mr. Davis, to correct, you're not here on possession of dangerous drug and drug paraphernalia. It's a different defendant we have today. You're probably a little bit confused about that. Not what you're here for today. So we just have you on a couple of warrants for failure to appear. That's all we have you here for today. And then with that clarification, does anyone else, any counsel want to be heard before court makes a ruling?
No, Judge.
Okay.
No, I'll stand there to see.
Okay. Right. Okay. In order to ensure appearance for the failure to appear, the court will set bond in the amount of $1,000 cash is secured to the Superior Court matter with release to pretrial services if bond is posted. Court is going to appoint Sarah Wright to represent the defendants. Prior release conditions are affirmed, and defendant, if he is released, is to contact pretrial services on the first business day following release. Next court date for Mr. Davis, criminal arraignment, and that's going to be at Superior Court, March 19, 2025, 1:30 p.m. So do make sure that you appear. If you are still incarcerated, you'll be made available by video for that arraignment. And so that's as to the Superior Court warrant. As to the Justice Court warrant, because you're already being held on the other warrant, the court's just going to set additional bond in the amount. This is to secure appearance. $250 cash is secured. And Gary Grinkowicz is appointed to represent you in that matter. Next next hearing is an arraignment tomorrow, 1:00 p.m. So that's March 13, 1:00 p.m. at the Justice Court with Judge Ball. And do make sure that you appear at that as well. Even if you do post bond on today's date, failure to appear can result in a warrant being issued. Any questions, Mr. Davis, before we conclude?
No.
Okay, you are excused. Thank you, sir.
Jason, the line.
Okay, good morning, sir. Can you state your name, please?
Jason Devine.
Mr. Devine, we've got you here today on two counts, two charges, one for possession of a dangerous drug, and then one for possession of drug paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You have a right to assistance of counsel, who is counsel seated next to you to assist you. The state is recommending that a steps hearing be set for you, and I'll explain what that is. And additionally, that you be released to the third-party supervision of pretrial services. Any additional record, Mr. Poston?
No, Judge.
And then, Mr. Devine, let me just briefly explain what the steps hearing is. That's a hearing where you'll be collaborating with the Pima County Superior Court on a diversion type program. And if you meet all requirements for that program, their charges may be dismissed as if they were never actually filed in the first place. And so is that something you want to avail yourself of?
I think so. Yes, sir.
Mr. Zarzicki, did you want to make any additional record?
No.
And would the defendant waive time as to setting the steps hearing?
We'll waive time for the steps hearing.
Okay. So at this time, then, the court will order releasing the defendant to the third-party supervision of pretrial services. Mr. Devine, the court is going to order, though, that you follow monitoring or treatment as directed by pretrial services and no consumption or use of alcohol or illegal drugs. Legal Defender's Office is appointed to represent you. We'll set your next hearings as follows. You have a steps hearing at Superior Court, March 19, 2025, at 9:00 a.m. at Superior Court. Additionally, your preliminary hearing as to the underlying charges, April 28th, 2025, 1:30 p.m. That'll be at Justice Court. And so since you're being released, that hearing may be moved. That date might be moved, but just check in with your legal defender. They can clarify all dates for you. Do you have any questions at this time?
I do not.
Okay, then you will be released today as indicated and you are excused. Thank you, sir.
Thank you. Judge, I'm going to write him a little reminder right now, just in case. It was March 19th at 9 a.m.
Yes, it is.
Okay.
So here's the phone number for premium services needed. There's your attorney's phone number to get in touch with them. And March 19th at 9 a.m. for election expert.
Zachary, you're up.
Okay, good morning, sir. Can you state your name, please?
Zachary Devine.
Mr. Devine, we have you here today on a couple of matters. We'll take them one at a time. Number one, we have that you were picked up on a fugitive warrant out of the state of Utah. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There's counsel seated next to you to assist you. Okay, so the state is recommending that bond be set as to the warrant. I know we had a spirited discussion yesterday about another case. The court's inclined to hold the defendant without bond pursuant to the statute, but Mr. Poston, any record?
The court summed it up accurately, Your Honor. No.
Okay. Mr. Zarzicki, any record as to that before we go to the city court matter?
What's the legal basis for holding you back after that?
Under ARS 13-3856, the defendant is alleged, let me see if I can pull up the information, but there's a fugitive warrant that was recognized, and that is for out of the 2nd District Court of Ogden, Utah. There was a forgery charge and a warrant was issued. And so under 13-3856, and also under the interstate compact that exists between the states as to these fugitive warrants, that the information before the court is that the on release following a conviction, that the defendant
conviction.
What?
This is a pre-conviction warrant.
He's correct, Your Honor.
Pre-conviction.
It is
Yes.
pre-conviction.
Oh,
Your Honor.
okay.
The state, upon further review, the state would recommend the $5,000 bond, which is the the amount that the Utah court implemented.
Okay, and then Mr. Zarzicki, as to the amount of the bond.
We're asking for the lease. He's a 1-on-1 on the scale. He's been a resident for 3 years, stable resident for 3 years. He has no priors prior to this. We're asking for him to be released so he can return to Utah and deal with that on his own. Please, please, please.
Mr. Zarzicki, can you discuss with the defendant and then articulate after that discussion what's the game plan for doing that?
Changing around.
All I'll say, Your Honor, is it is a extraditable warrant which speaks to Utah wanting him quite badly.
All right, Your Honor, first follow up on what Mr. Poston said. It's a non-violent crime. It's forgery. It is an extraditable warrant, but every felony is an extraditable warrant. It's a 5K bond, so I would argue that Utah doesn't really like that way. I did speak with him. His mom can provide him transportation back to Utah. He said he can do it within the next week. So we would ask for release and set a review hearing on the status of the warrants in a couple of weeks. And hopefully that he'll be able to get taken care of.
So the next hearing that would be set on this would be a warrant hearing on the 17th next week. So that's the court's inclination, is to set it as the warrant review at that time.
If you remember for sure.
What is the name of the defendant's mother?
What's your mom's name? My mom's name is it's Tammy Ryan.
And can you spell her first and last name?
Yeah, it's Tammi Ryan, Ryan, and she's of Brigham City, Utah.
Oh, she does not live here in Arizona.
That's correct. She lives in Utah. So she would be coming down to take her back. Yeah.
Okay. At this time, what the court's going to do is the court's going to order releasing the defendant to the third-party supervision of pretrial services. The court is going to appoint the Pima County Legal Defender's Office to represent the defendant. The court is going to order Mr. Devine that you appear in person at an arraignment. At the fugitive warrant hearing, which is going to be set March 17, 2025, here in the Pima County Superior Court. So if you're going to take care of the warrant in Utah, you're going to have to wait until after that hearing, unless you can make it up to Utah and get back before. A warrant will issue for your arrest if you're not present in person at the arraignment on March 17. I'm frankly a little bit confused about what's happening in this particular case. Normally we hold folks without bond on these issues, and there's not really an argument as to that. I'm not really sure, but under the circumstances, I'm just going to order that you, as a compromise, that you appear in person.
Thank you.
Okay. Mr. Poston, did you want me to indicate that over the state's objection?
Yes, please.
Okay. Court will further indicate that the ruling on today's date is over objection of the state. And so then again, the next hearing, March 17, 2025, 2:30 p.m., that's when you need to appear at the Superior Court. So make sure that you appear at that, Mr. Devine. We have one other additional matter to address for you today. And that's going to be a city court matter. It's probably why the warrant came up in the first place. You have a pending charge of drug paraphernalia. It's a misdemeanor offense. You do have a right to remain silent. Anything you say can and will be used against you. Court at this time is going to release you on your promise to appear at future proceedings. Your next court date in this matter as to the drug charge in city court is going to be April 10, 2025, 9:30 a.m. You're not to possess or consume any alcohol or illegal drugs for the duration of this case. And any questions before you're excused for today's date?
Not for me.
Okay. All right. Then you are excused. Thank you, sir.
Thank you so much. I appreciate it. Thank you.
The lawyer ASAP to make sure you make that mistake.
Okay, perfect. And I'll be here for be back for April 10th. Yep, and that's the city. Okay. So the address is right there. So thank you so much. Thank you. Thank you, Your Honor.
Morning, sir. Can you state your name, please?
Keith Richard Gonzalez.
Okay. Mr. Gonzalez, you're here today on, it appears, failure to appear on some prior offenses from December 2024, felony offenses of possession of a dangerous drug, possession of a narcotic drug, and drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. Counsel is seated next to you for your assistance. Let me just review something really quick before I make a record as to this recommendations. Okay, the state is recommending bond be set in the amount of $2,500 plus release to pretrial services. Any additional record, Mr. Poston?
Nothing further, Your Honor.
And Mr. Zarzicki?
Judge, this is one of these cases which, quite frankly, really annoying me. He was not initially arrested on this case. There was an indictment followed by direct summons that was mailed to here. Frankly, the fact that mailing is acceptable as a way to summon somebody for a criminal charge is the annoyance that I have. If this were a civil case, he would have to be served in person, yet somehow it's acceptable just to send him something mail and expect him to show up. He indicated he never got the summons. Quite frankly, given the nature of the U.S. mail right now, I think that's highly possible. Additionally, he scores a 2 and a 3 on the scale. He has 1 nonviolent drug prior from 2009, lifelong Tucson residence, has employment as a drywall repairman. I don't think there's any reason to believe he's a threat to the community. And as far as his failure to appear on this case, like I said, given that he was never even arrested in the first place, there was a direct indictment and then a summons that he never got. I don't see how he had any notice actually to be at. So we would ask that he be released to pretrial services.
I tend to agree. This doesn't appear to be one of those situations where we have a defendant who was released at an initial release to pretrial. They don't show up. They got notice. So I think there could be some notice issues here. For those reasons, the court will order releasing the defendant on his promise to appear at future proceedings. And let me indicate, so the court is going to appoint the Pima County Public Defender's Office to represent the defendant. As a condition of release, Mr. Gonzalez, no alcohol or illegal drugs until further court order. Your next court date is an arraignment, March 19, 2025, 1:30 p.m. at Superior Court. You didn't show up at the last one. There may have been a notice issue. There's not a notice issue any longer. You have notice today of when your next court date is. That's going to be a week from today, 1:30 p.m. At the Pima County Superior Court. Probably on the 3rd floor, but double check it when you get to the courthouse. Failure to appear can result in a warrant being issued. And then if we're having to do this process all over again, the court may just end up holding you to make sure that you get to the court date. Does that make sense?
Yes, it does.
Any questions at this time?
No.
Okay, you're excused. Thank you.
Sure.
Brad?
All right, good morning, sir. State your name, please.
Stephen Grove.
Mr. Graham, we have you here today for a couple of felony charges for possession of narcotics and promoting prison contraband. We have another set of city court matters we need to address next. But as to these felony offenses, you do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and counsel is seated next to you for your assistance. The state in this matter is recommending bond be set in the amount of $7,500 plus release to pretrial services if bond is posted. Any additional record, Mr. Poston?
No, Your Honor, other than noting the hold that he has.
Okay. And can the jail confirm, do we have a felony hold or superior court hold?
APO. Showing superior court, Your Honor.
Your court. Probation?
Yes.
Okay, thank you. So, Mr. Graham, what that means is that regardless of what the court's decision would normally be regarding release, there is a probation hold, so the court is not able to fully authorize release on today's date. So we need to talk about what type of bond is going to be set. State's recommending bond in the amount of $7,500. And then Mr. Zarzicki, anything on behalf of the defendant?
I'll just note, given his financial circumstances, he's unemployed. He says is struggling some stuff. In addition to the fact that already is that probation hold we asked for.
This time, court will set bond at the amount of $1,000 cash if secured with release to pretrial services. If bond is posted, court will order no alcohol or illegal drugs for the defendant. Mr. Illis, John Illis, is appointed to represent the defendant. Next court date as to these felony charges is going to be March 24th, 2025, 1:30 p.m. at the Justice Court for preliminary hearing. The court is going to move now to the city court offenses that we have. So Mr. Graham has a wide array of failures to appear for city court charges. Court shows, I believe, 9 pending charges, or there are 9 pending with the defendant. In order to ensure the defendant's appearance at future proceedings in city court, the court is going to set bond in the amount of $1,000 cash or secured. Court will appoint the city public defender's office to represent Mr. Graham. And next court date for Mr. Graham is going to be as to these matters. That is going to be on March 21st, 2025, 1:45 p.m. for video review with Judge Hale. And any questions, sir, before we conclude?
What do I have new charges right now?
So yeah, you got hold on one second. Let me mute it. I think we're good, Your Honor.
Okay, your excuse, sir. Thank you very much.
Thank you.
Showing Haynes.
Okay, good morning, sir. Can you state your name, please?
Kerwin Yates.
Sorry, can you say that one more time?
Kerwin Yates.
Okay, Mr. Haynes, you're here today on a charge of aggravated assault, domestic violence. This is a class 4 felony. You do have a right to remain silent. Anything you say can and will be used against you. Do you have a right to assistance of counsel? There is counsel seated next to you to assist you. The state is recommending bond be set in the amount of $35,000 with release to pretrial services if bond is posted. Mr. Poston, any additional record?
Your Honor, this involves a brutal assault with strangulation. The state need not remind the court of the statistics regarding lethality in cases involving strangulation. Defendant lives in New Mexico, has no reasonable contacts or ties to this community. And he, based on the narrative, he absolutely threw this person around like a rag doll after strangling her.
And Mr. Zarzicki?
Can I have a second to speak with him?
That's fine.
Your Honor, let me address one thing at a time here. So first off, as far as the underlying charges go here, obviously these are all allegations. The issue, the main reason this is a felony, in fact, the only reason I can determine that this is not a complaint is the allegation of strangulation. Obviously, he disputes all of that. It does not look like there's really any evidence of that aside from the complaints of the victim. As to the state's contention that she was thrown around like a rag doll, again, the interview complaint is she was pushed off. If we take everything that the officer says on his word, there was a strangulation. He was pushed off, and in the tussle that happened afterwards, he pushed her, and she fell onto the table. Again, dispute that all that happened. But worst case scenario, even if you take everything at face value in the end of the complaint, there is a black eye. I mean, that is the sum total of the truth. As to the statistics of the lethality, blah, 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 that might apply to people in general. Mr. Haynes, however, has no prior criminal history. There's no allegations of prior domestic violence. Those statistics also require recurring patterns of domestic violence, which we don't have here. There is some concern about his residence. I do understand his only permanent residence is in Shiprock in Virginia, Mexico. I know this court might not be inclined to release him and allow him to return to New Mexico. We would ask for that. The court is willing to do that. Barring that, we would ask for a much lower bond, something more than $5,000.
So what's apparent from the complaint is that there were photographs of injuries that were sustained. So I think it goes just beyond mere statements. Second, the allegations implicate that the party's minor child had to watch the defendant attack his mother, and the court is concerned about that as well and the trauma that that's going to inflict on that child. And the court has previously found probable cause on today's date as to the pending underlying charges. So in order to ensure the defendant's appearance and based upon the severity of the allegations, the court is going to order setting bond in the amount of $35,000 cash is secured with release to pretrial services if bond is posted. Conditions of release include no alcohol or illegal drugs, no acts of domestic violence, no firearms or weapons, and to surrender any firearms or weapons if any are possessed. Follow monitoring or treatment as directed by pretrial services. No contact with the victim, Jerry Garfield. Do not go to her residence or workplace. Pima County Public Defender's Office is appointed to represent the defendant. And next hearing is set March 24th, 2025, 1:30 p.m. at the Justice Court for preliminary hearing. Any additional questions, Mr. Haynes? Okay, then you're excused. Thank you, sir.
Desiree Montaño.
Good morning, ma'am. Can you state your name, please?
Desiree Montaño.
Ms. Montaño, we've got you here for a couple of matters today. Looks like we have some matters in Superior Court, failure to appear for City Court. We also have some City Court matters to talk about second, but we'll start with Superior Court. There is a failure to appear on or around January 7, 2025 relating to felony offenses of drug possession, dangerous drug possession, narcotic drug possession, and drug paraphernalia. So you do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. Counsel is seated next to you to assist you. Just take a look at one thing really quick before we get to the state's recommendation. Okay, yeah, it looks like you were arrested for the initial charges. You were released at the initial appearance and notified about, let me see. Like a superseding and supervening indictment was issued. No contact with pretrial services. Okay. State's recommending that bond be set in the amount of $2,500 plus release to pretrial services. Any additional record, Mr. Poston?
No, Judge.
Okay. And then Mr. Zarzicki?
I did not specifically try to pull the information on this, but based off the timeline, this had to have been a dismissal. She was arrested on 9/23/24. A supervening indictment was mailed on New Year's Eve on 12/31. That's far too long of a gap. The state must have dismissed in the interim. Either that or I don't legal. was a legal preliminary hearing set. It was after 12/31. Given that there was a dismissal in the interim, abdicated or need to keep checking in with pretrial services. Obviously, she being arrested and having the initial clearance, she was on some degree of notice. But I think that is somewhat truncated fact pattern here. I'll point out she has no priors. I know based on the failure to appear history on both this case and the two safer cases, the court's probably not chomping at the bit to let her out, but there are no priors here. She does have a legitimate reason why she would have missed this arraignment. She also had some additional hearings she was dealing with at the time.
Two different dates.
Got it. On two different listed dates. She was confused. Pretrial service was no longer involved once the case got dismissed. She is a lifelong resident. Her grandmother is willing to offer housing if she's released. We'll defer to the court. I would ask for release to pretrial services, and if not, I'd ask for, given that this is not a drug offense, bond or rental policy 1500.
At this time, court is going to, in order to ensure the defendant's appearance, court will set bond in the amount of $500 cash or secured. That's the warrant amount that was issued back on January 7th. So that's $500 cash or secured. Court will order any prior release conditions are affirmed. Pima County Public Defender's Office is appointed to represent the defendant. Next court date for these charges will be the arraignment, March 19, 2025, 1:30 p.m. at Superior Court. Ma'am, are you listening? You'll have a chance to speak with counsel, but I need you to hear these dates. You have a substantial failure to appear history. That's why I'm holding you. I'm concerned if you're not listening, then you're not going to make the court dates again. So bond is set, $500 cash is secured. Pima County Public Defender's Office is appointed. Prior release conditions are affirmed. Next court date, March 19, 2025, 1:30 p.m. at Superior Court. You'll be made available virtually for that proceeding if you're still incarcerated. You need to appear even if you postpone. As to the city court matters, you have failure to appear on assault, disorderly conduct, and having an open container as a passenger. These are misdemeanor offenses. You have a right to remain silent. Anything you say can and will be used against you. As previously noted, substantial failure to appear history. You are being held on as this matter, so the court is going to ensure your appearance. Bond is set, $50 cash is secured for the city court matter. Prior release conditions are affirmed. City Public Defender's Office is appointed to represent you. And your next court date in this matter is a video review, March 21st, 2025 at 1:45 p.m. with Judge Cranshaw. And so those will be your next court dates and your excuse. Thank you, ma'am.
Olsen,
Walk the other way.
to your left, ma'am.
Good morning, ma'am. Can you state your name, please?
Christina Paulson.
Ms. Paulson, we have you here for a couple of matters today. We'll take them one at a time. First matter that we have you here for today on initial appearance, 2 felony charges, possession of narcotic drugs and possession of drug paraphernalia. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel. There is counsel seated next to you to assist you. Mr. Poston, let me verify what the state's recommendation is on this. There is a check mark for the steps hearing. Is bond being requested?
Your Honor, this person is a 6 out of 6 twice over, but for that issue, we would have immediately gone ahead and just said PTS with steps However, the state needs some sort of assurance in the form of a bond that she's actually going to show up, all things considered.
Okay. Mr. Zarzicki, any record that you want to make?
Yeah, I'm not sure. We're always at a loss on this because all we get is the final pretrial services thing, and despite all of the training that the pretrial services staff has been kind enough to give us on these, I'm not sure where the 6 out of 6 would come from. She has one theft prior from 2012. I would assume there's some failure to cure history. That would be the only possible thing. Aside from that, she's a 28-year residence. She has employment as a merchandise seller. She has a stable residence. This is entirely a drug possession case. There's really I don't believe there's any indicator of sales. She's in charge with sales. There were some drugs found allegedly in her purse, and that's the authority of why she's here. She is an excellent candidate for steps. Again, I understand Mr. Poston's position. I don't understand where that 6 out of 6 comes from. We would ask the court to consider her releasing her pretrial services and setting the steps here.
I think where it probably comes from is in looking at the prior history on the theft charge. We have failure to appear at sentencing, probation revoked, absconded from parole, and then having to do so. There's a lot of failure to comply here. I'm seeing a lot of failure to show up at city court matters as well. So there is a lot of concern there.
And that was my assumption as well, Your Honor. I'll just note that all of that stems from the case that's kept on. So, as far as the problems, as to city court, I can't speak as much to that.
Okay. All right. At this time, over objection of the state, court will order releasing the defendant to the third-party supervision of pretrial services. Court will set. Ms. Paulson, we have something called the STEP program. It's a diversion program to see if you complaints missed. Would you like to avail yourself of that program?
Yes.
And is the defendant waiving time for preliminary hearing?
He is.
All right, so the court will order setting a stepped hearing in this matter, March 19, 2025, 9:00 a.m. at Superior Court for the stepped hearing. And additionally, preliminary hearing is moved out April 28, 2025, 1:30 p.m. As conditions of release, no alcohol or illegal drugs. You must follow monitoring or treatment as directed by pretrial services. And the Pima County Public Defender's Office is appointed to represent Ms. Paulson. Ms. Paulson, a lot of failure to appear. We're going to address some other failure to appear in just a moment. I am taking into account that the theft case did happen several years ago. The conduct that was alleged to have occurred happened over 6 years ago, the most recent instance. So I'm going to try to give you the benefit of the doubt on the failures to appear, but I'm starting to see a pattern, and maybe I'm making a mistake here, but don't make me look foolish, okay?
Okay, Your Honor.
And so that'll be for the Superior Court matter. Let's go to, we do have a failure to appear for Injustice Court. That's before we get to the City Court matter. It's for failure to appear on shoplifting charge. The court is going to order releasing you on your promise to appear at that hearing. And the court is going to order that you not go back to the incident location for that shoplifting charge that previously was charged. You have a hearing for the shoplifting matter. It's on March 24th at 8:30 a.m. And that's a Justice Court. That's an arraignment with Judge Foster at Justice Court. So make sure that you appear at that as well. Mr. Zarzicki, I assume, is getting all these hearings written down for you. March 24th, and that's 8:30 a.m. All right. So lastly, we'll go to your city court matters. And this is, as we've indicated, failure to appear for criminal damage and theft. Court's going to give you one more opportunity, Ms. Paulson, to make good on your ability to appear at these proceedings. Court is going to order that you be released on your promise to appear. It's going to set your next hearing as a pretrial hearing, April 10, 2025, 9:00 a.m. And that's with Judge Maldonado over at the City Court. So you've got a few court dates. Please make sure you keep track of all these. If you do not appear, a warrant can be issued, and the next judge who looks at this may not be as flexible as I am. Any questions at this time, ma'am?
No, Your Honor.
Okay, you are excused. Thank you.
Wilbur. Wake up. Have a go.
All right. Good morning, sir. Can you hear the court?
Yes, I can.
All right. And can you go ahead and state your first and last name?
Daniel Thomas Wilburn.
Mr. Wilburn, you're here today on a few matters today. We're going to go ahead and take them one at a time. First matter we're going to talk about is some newer offenses regarding possession of a narcotic drug and possession of drug paraphernalia. These are felony offenses. You do have a right to remain silent. Anything you say can and will be used against you. You do have a right to assistance of counsel, and counsel is seated next to you to assist you on today's date. State is recommending bond be set in the amount of $2,500 plus release to pretrial services. The court does note that you do have, is it a probation hold jail on the defendant?
Yes, Your Honor, it is.
Okay. And so, Mr. Wilburn, regardless of what the outcome would normally be today, the court is unable to fully release you on today's date because of the probation hold. That needs to get resolved. The state, though, as to bond, is recommending $2,500 be set for the bond. Any additional record, Mr. Poston?
No, Your Honor.
Okay. Mr. Zarzicki, any additional record as to this matter?
Judge, given the APO hold and assessment of pretrial services, we'll defer to the state.
Okay. Court is going to, and this is in part based upon the hold existing, the court will order bond be set in the amount of $1,000 cash and secured with release to pretrial services. The bond is posted. Additionally, court will order no alcohol or illegal drugs, and the Pima County Public Defender's Office, contract attorney is on this one. So we'll go ahead and do Mr. Illis on behalf of the defendant for this matter. Oh, I'm sorry. I take it back. We have another matter that I see we're here for with Justice Court. Let me check on something really quick. Okay. All right. Yeah. So Mr. Illis is to represent the defendant as to this these drug charges. No alcohol or illegal drugs as a condition of release. Next court date for these charges is going to be March 24th, 2025. It's going to be at 1:30 p.m. at Justice Court. And we'll go ahead and move on to the next matter, which is a failure to appear for DUI charges from 2021. At request of Judge Foster, court is going to set bond in the amount of $2,499 cash is secured, and is setting a we're going to set for a judge's review, and that's going to be March 13, 2025, 11 o'clock a.m. Jill Gukin is appointed to represent the defendant. Any prior release conditions are affirmed. So that date again is a judge's review, a special judge's review at Justice Court, March 13, 2025 at 11 o'clock a.m. with Judge Foster. And then finally, we have some city court matters to take care of. And this is going to be for, looks like we have a total of 6 warrants, which were issued for failure to appear on about 10 different charges, misdemeanor charges, for which the defendant does have a right to remain silent, and that anything he says can and will be used against him. And it looks like there's a special note by Judge Maldonado that the defendant has never appeared out of custody since any of the matters have commenced. So we do have a substantial failure to appear history. Court will set, given that bond's already set in the other matters, the court is just going to set bond in this matter to ensure appearance in the amount of $500 cash is secured. Court will appoint, looks like we'll go ahead and I'll appoint Mr. Grinkowicz again, Jeff Grinkowicz, to represent the defendant. We'll see if that can be helpful. And any prior release conditions additionally will be affirmed. Okay, and so next court date for all those city court matters, that's going to be on March 21st, 2025, 1:45 p.m. with Judge Maldonado at the city court, March 21st, 2025, 1:45 p.m. Okay, lots of different hearings and information. Mr. Wilburn, any questions at this time?
No.
Okay, with that, you are excused. Thank you very much. Okay, that should do it for today's initial appearances. Thank you, counsel. Thank you, pretrial services. Thank you, jail.
All right.
I gotta look into everything. Shut it up. Thanks, everyone. Please be seated.
I gotta change it.
What's happening?
We put the main switches.
Oh, yeah, we switched it up on you. We like to keep you guys on your toes.
That's weird, so the first page has you. And then.
Because they switched it in there.
Yeah, the switches are wrong.
Okay, good morning, everybody. My name is Commissioner Hughes. This is the 11 a.m. initial appearance calendar for Wednesday, March 12th. The court's orders for the taking of DNA samples and fingerprints issued on the first calendar of March will apply to all of the hearings on this calendar. Did we get an interpreter? We don't need one, but they're not logging in anyway. Okay. All right. As we get started in here this morning, I will call each of you into the courtroom one at a time. I will ask one of you to stand behind this gray podium here in front of me in the courtroom. I'll ask the next two people that I intend to call into the courtroom to line up in the chairs right inside this door. I think there's one blue, one green chair. So I will ask one person to come all the way into the courtroom. The second person I'll ask to move to the second chair. The third person, well, I don't know. I don't know how that'll all work out. But if you're not in the courtroom, you'll either be in one of those two chairs. And so we'll cycle through the calendar. You'll go from that second chair to the first chair, from the first chair into the courtroom. I tell everybody, I know that sounds sort of like an exercise in musical chairs, but I assure you all it will make this calendar move much quicker. So if you'll listen for your name and follow that chair progression, everybody will get to where they're supposed to go a little bit quicker. Once you work your way into the courtroom and you're behind the podium, I will start by asking you to state your full name and date of birth. I will then explain to you what the allegations against you are or tell you why you're here this morning. After that, I will tell you whether you qualify for a court-appointed lawyer, sometimes called a public defender, to represent you. If you do not qualify for a public defender, you have the right to hire a lawyer at your own expense to represent you in all criminal proceedings. After we talk about whether you get a lawyer, I will give you the next court hearing dates and times you'll be required to attend after this court hearing. And the last thing we'll do while you're in the courtroom is talk about whether you are legally eligible for release from custody this morning. If you are, we will talk about what the terms and conditions of your release will be. In addition to that right to the assistance of counsel, you all also have the right to remain silent. These are recorded criminal proceedings. That means anything that you do choose to say in the courtroom this morning will be preserved on the record and can be used against you at any point down the line in these proceedings. Whether or not you qualify for a court-appointed lawyer, there will not be a lawyer in the courtroom this morning for purposes of your defense. Because you will not be represented in here this morning, and because anything you say could be used against you, I will strongly caution all of you not to make any statements regarding the facts about why you're here. The last thing I'll tell you all before we get started is that all of the information I give you while you're in the courtroom will be contained in a written document called a release order. You will get a copy of that document when you're done in the courtroom and you step back into the room that you're in right now. So please don't feel like you need to memorize what we go through while you're in the court, but please keep that paperwork with you wherever you go from here, because in that paperwork will be all the information you got while you were in the courtroom. I don't understand the question. No, it's not. Okay, sorry about that. Let's go ahead and get started. Can I please have Kai Cienfuegos all the way into the courtroom behind the gray podium? Jeffrey Williams, if I could ask you to take a seat in that first chair. Timothy Haggerty, if I could ask you to make your way to the second chair, please. Can I have your name and date of birth, please?
Hello, ma'am. My name is Kai Felix Cienfuegos. My date of birth is 4/20/97.
Thank you, Mr. Cienfuegos. You are here on an allegation of a new charge. The allegation against you is one count of theft of a means of transportation. It is a Class 3 felony. I have found probable cause to support that allegation, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. They will both be at 8:30 in the Superior Court downtown. Because this is a felony allegation alleged to have been committed while you were on pretrial release in a different felony case, you are not eligible for release on bond. You will be held in custody without bail, at least until an evidentiary hearing is held. That hearing is scheduled for March 19th at 1:30 in the afternoon. Between now and that hearing on the 19th, you will be held without bond. Do you understand that information?
Yes, ma'am.
Okay, thank you very much, sir. You can step back to your left and get your paperwork. Jeffrey Williams, if I could ask you to please work your way into the courtroom. Vladimir Portillo Mendeville, if you would work your way to the second chair, please. Can I have your name and date of birth, please, sir?
Jeffrey Gene Williams, the 2nd, April 1st, 1988.
Thank you, Mr. Williams. You are here on allegations of new charges. The allegations against you are one count of dangerous drug possession for sale, that is a Class 2 felony, one count of theft of a means of transportation, a Class 3 felony, one count of dangerous drug possession, one count of narcotic drug possession, one count of use of an electronic communication in a drug transaction. Those 3 allegations are Class 4 felonies. And finally, one count of drug paraphernalia possession, which is a Class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. Both of those will be at 8:30 in the Superior Court downtown. Because these allegations are all felony offenses alleged to have been committed while you were on pretrial release in a different felony drug case, you are not eligible for release on bond. You will be held in custody without bail bail, at least until an evidentiary hearing is held. That hearing is scheduled for March 19th at 1:30. Between now and that hearing on the 19th, you will be held without bond. Do you understand that information?
There's no, well, I guess, why can I not get bonded out?
Arizona law says that if you allegedly commit a felony offense while you're on pretrial release in a different felony matter, you're not eligible for release on bond. So the reason you can't have bond is because Arizona law does not allow it under the facts of this case.
What other case?
It looks like you are on pretrial release in a felony case involving possession of narcotic drugs. Your next court date in that case looks like it is March 18th. Any other questions, Mr. Williams?
There's nothing I can do
in order to get out, you mean?
to get bonded out?
No, at least not between now and the 19th. Anything else? Okay, thank you, sir. Timothy Haggerty to the podium in the courtroom, please. Michael David Hall, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
Tim Haggerty, 10/21/1982.
Thank you very much, Mr. Haggerty. Is your legal first name Timothy?
Yes.
Okay, thank you. You are here on 3 different matters. The first matter that you're here on is allegations of new charges. Those allegations are 2 counts of dangerous drug possession for sale, both class 2 felonies. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th, and then a preliminary hearing the 20th. Both of them will be at 8:30 in the Superior Court downtown. On those new allegations, I have imposed a $25,000 secured appearance bond. The other 2 matters that you're here on are both allegations that those new charges violated term 1 of your probation. In both of those probation cases, I have appointed a lawyer to represent you. Your next court hearing in each of the probation cases will be a revocation arraignment March 19th. It'll be at 8:30 in the Superior Court downtown. On one of the 2 probation cases, you have a $500 secured appearance bond. On the second probation case, you're not eligible for release on bond. So what that means, Mr. Haggerty, is that on the one probation case, you will be held in custody without bond, at least until you see the probation judge on the 19th. Because of that, I encourage you to wait until after that probation hearing before attempting to post the bond on the new charges in the other probation case.
25,000.
It'll be $25,500 total, $25,000 on the new charges, $500 on the second probation case. But on the 19th, it's possible that the probation bond will go away. So I would say go to the probation hearing on the 19th, see what the probation judge does on the probation cases. The day before that hearing, the 18th, you'll go to the court on the new charges and you'll meet with the lawyer that's going to defend you. So you can talk to that lawyer about the fact that you have that probation hearing the next day and see what the lawyer tells you about the bond on that new case.
I'm less worried about the bond on those cases as I am on the allegations of for sales, and I'm curious as to why they're actually going to try to push for sales on 1 ounce. I mean, it's personal.
So talk to your lawyer about that, but I'll tell you, based on the information provided to me by law enforcement, for purposes of this hearing, the sales allegation comes from the weight of the drugs seized. So if you think that doesn't qualify for the sales threshold, or there's some miscommunication or some false information, talk to your lawyer about that, because certainly if that's true, your lawyer will want to establish that and present it to the trial court. Okay, anything else, Mr. Haggerty? Okay, thank you very much. You can step back and get your paperwork. Vladimir Portillo Mendival to the podium in the courtroom, please. Jose Felix Lopez, if you would please work your way to the second chair.
Vladimir Portillo Mendival, Febrero 17, 06.
Do you speak English?
Yeah.
Do you feel comfortable conducting this hearing in English?
Yeah, it's fine.
Okay, did you just give me your date of birth in Spanish, though?
Yeah, it's good.
Okay, can I have it in English?
Yeah, February 17, 06.
Thank you very much. Okay, you are here on allegations of new charges. The allegations against you are 2 counts of discharging a firearm at a residence. Those are both class 2 felonies. One count of discharging a firearm at a structure, that is also a class 2 felony, and 3 counts of discharging a firearm at a non-residence. Those are all class 3 felonies. I have found probable cause to support these allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. They will both be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $1 million secured appearance bond. Secured appearance means you can use a bonding company to post that bond if you choose to. If you do post that bond prior to your physical release from custody, you will be affixed with an ankle monitor. If you post that bond and you're released on the ankle monitor, you cannot return to the scene where any of the underlying allegations took place. You cannot have contact with any alleged victims, witnesses, or co-defendants. You also cannot possess any weapons if you're released from custody. Do you understand those conditions?
Yeah, I understand.
Okay.
I had a question.
Sure.
So I'd have to pay how much to get on the incubation?
Well, you can use a bonding company.
Yeah.
If you want to know what a bonding company's specific requirements would be, I will encourage you to find a list of bonding companies back in the jail and call them and ask them. My general understanding is that bonding companies require a minimum of 10% up front.
Yeah.
10% of 1 million would be 100,000, I think. But don't rely on my calculation on that. Call some bonding company. You could call every single one on the list if you want to and see if you can find one that will work with you.
I appreciate it.
Okay, thank you, sir. Michael David Hall to the podium in the courtroom, please. Jasmine Thomas, if I could get you to work your way to that second chair. Can I have your name and date of birth, please?
Michael David, and then date of birth is 09/12/2006.
Thank you very much. And is your last name Hall?
Yeah.
Okay, it's not Tycoon Hall. It's not a hyphenated last name?
Michael David is the first name, Tycoon's the middle name, Hall's the last name.
Very good. Okay, thank you, Mr. Hall. You are here on allegations of new charges. The allegations against you are 1 count of narcotic drug possession for sale, 1 count of conspiracy, 1 count of narcotic drug possession for transportation or sale, 1 count of possession of marijuana for transportation or sale. All of those are class 2 felonies. 1 count of marijuana possession for sale, 1 count of money laundering, 1 count of illegal control of an enterprise. Those are all class 3 felonies. 1 count of use of an electronic communication device in a drug transaction, 1 count of possession or use of a weapon in a drug offense. Those are class 4 felonies. 1 count of being a minor carrying a firearm, and 1 count of tampering with physical evidence. Those last 2 are class 6 felonies. I have found probable cause to support all of these allegations except conspiracy and tampering with evidence. I did not find probable cause to support those 2 allegations. I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. Both of those hearings will be at 8:30 in the morning in the Superior Court downtown. On the allegations that I did find probable cause to support, I have imposed a $150,000 secured appearance bond. If you post that and you are released from custody, you cannot have contact with any alleged witnesses, and you cannot possess any weapons or drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay, thank you, Mr. Hall. You can step back and get your paperwork. Jose Felix Lopez to the podium in the courtroom, please. Matthew Romero, if you would please work your way to the second chair. Can I have your name and date of birth, please, sir?
Hi, Honor. My name is Jose Angel Felix Lopez, date of birth 9/22/02.
Thank you very much, Mr. Felix Lopez. You are here on allegations of new charges. The allegations against you are 2 counts of aggravated assault with a deadly weapon, both class 4 felonies, 2 counts of endangerment, both class 6 felonies, and 1 count of discharging a firearm in the city limits. That's a class 6 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearing will be a status conference March 18th and then a preliminary hearing March 20th. Both of them will be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $25,000 secured appearance bond. If you post that bond and you are released from custody, you cannot have contact with any alleged victims or witnesses. You also cannot possess any weapons or any drugs without a valid prescription if you're released from custody. Do you understand those conditions?
Yes, Your Honor.
Okay, thank you very much. You can step back and get your paperwork. Jasmine Thomas to the podium in the courtroom, please. Jane Mitchell, if you would work your way to the second chair. Can I have your name and date of birth, please?
Yeah, it's Jasmine Renee Thomas and 3/14/86.
Thank you, Ms. Thomas. You are here on allegations of new charges. The allegations against you are 5 counts of trafficking in stolen property, all Class 2 felonies, 5 counts of organized retail theft, Class 4 felonies, and 5 counts of shoplifting, all Class 1 misdemeanors. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and a preliminary hearing March 20th. Both of them will be at 8:30 in the Superior Court downtown, and I have imposed a $10,000 secured appearance bond on these allegations. If you post that bond and you are released from custody, you cannot return to the location where any of the underlying allegations took place. You cannot have contact with any alleged witnesses or co-defendants if there are any, and you cannot possess any drugs without a valid prescription if you're released. Do you understand those conditions?
I do.
Okay, thank you, Ms. Thomas. You can step back and get your paperwork. Matthew Romero to the podium in the courtroom, please. Victoria Martinez, if you could work your way to the second chair, please.
Good morning, Your Honor.
Good morning. Can I have your name and date of birth, please?
Yeah, Matthew Romero, 2/17/1985.
Thank you very much, Mr. Romero. You are here on allegations of new charges. The allegations against you are 1 count of aggravated driving under the influence, that's a Class 4 felony, 2 counts of misdemeanor driving under the influence, 2 counts of extreme driving under the influence, also misdemeanor allegations, 1 count of driving on a suspended license, a Class 1 misdemeanor, and last, 1 count of extreme driving under the influence with a blood alcohol content of 0.20 or more, also a Class 1 misdemeanor. I have found probable cause to support these allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. Both of them will be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $7,500 secured appearance bond. If you post that bond, you are ordered not to possess or consume any alcohol or drugs without a valid prescription. If you post that bond and you're released, you are also prohibited from operating a motor vehicle while this case is pending. Do you understand those conditions?
Yes.
Okay, thank you very much. If you'll hang out right there for 1 second, that's my mistake. Sorry, Ash. He's got your paperwork right here, if you want to step back to your left. Thanks, Mr. Romero. Jane Mitchell to the podium in the courtroom, please. Robert Colarusso, if you'd work your way to the second chair. Can I have your name and date of birth, please?
Thanks, Jane Mitchell, 092906.
Thank you very much, Ms. Mitchell. You are here on a probation violation warrant. A petition to revoke your probation was filed. It alleges that you have violated terms 3, 4, 5, and 15 of your probation. I have appointed a lawyer to defend you in those probation proceedings. Your next court hearing will be a revocation arraignment March 19th. It'll be at 8:30 in the Superior Court downtown. And on that warrant, you have a $5,000 secured appearance bond. If you post that bond and you are released from custody, you cannot possess any weapons or any drugs without a valid prescription. If you are released from custody, you also must contact your probation officer within 3 days of being released. Do you understand those conditions?
So does it mean I have to stay? Does it mean I have to stay here?
If you don't post that bond, you will stay in custody at least until your hearing on the 19th. All right. Thank you, Ms. Mitchell. Victoria Martinez to the podium in the courtroom, please. Ray Lujan, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Victoria Martinez, 9/14/91.
Thank you, Ms. Martinez. You are here on 2 different matters. The first matter you're here on is a failure to appear warrant issued by the Gila County Superior Court on an existing felony case involving possession of burglary tools. I don't know whether or not Gila County has already appointed a lawyer to defend you in that case. If they have, the lawyer assigned to you will continue to defend you. If Gila County has not yet appointed a lawyer for you, they will at your next court hearing. That hearing will be an arraignment hearing March 17th at 8:30 in the morning in Gila County. The Gila County judge has issued a $2,500 secured appearance bond on the Gila County warrant. Did you have a question about your Gila warrant?
I actually went this last August up there and I paid the fines and everything, and I have the warrant quash paper and everything. It's in my property.
Okay, can you look into that? All right, so here's the deal. I'm gonna see, so it looks like these records indicate that this warrant was issued February of 2024. It looks like Gila County has confirmed it as a valid warrant as of yesterday, March 11th. So I'm asking my clerk to look into that and see if she can confirm with Gila County that warrant was quashed. Because it looks like they're telling us that it's valid.
Yeah, I went in
so
July.
we're going to look into that. If you'll take a step back to your left, stay here. If they clear the gallery, stay in here because we still have another matter with you that we have to talk about. But I want to see if I can get some more information one way or the other on that Gila County.
Yeah, if you ask the judge, I went in July.
I'm not sure we'll be able to get a hold of the judge, but we'll work on it. So if you'll just step back to your left. Don't leave though, Ms. Martinez, because I'm going to call you back in at some point. Don't stay, just sit where you were, and we'll get back to you here. Okay, Robert Colarusso, if you would please work your way into the courtroom. Joanna Morales, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please?
Robert Colarusso, 1/26/60.
Thank you, Mr. Colarusso. You are here on allegations of new charges. The allegations against you are 3 counts of disorderly conduct and 3 counts of criminal damage. They are all Class 1 misdemeanors. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearing will be an arraignment hearing March 18th. It'll be at 9 o'clock in the morning in the Peoria Municipal Court. On these allegations, I have imposed a $1,000 secured appearance bond. If you post that bond and you are released from custody, you cannot return to the scene where the underlying allegations took place. You also cannot have contact with any alleged victims or witnesses. If these orders mean that I'm ordering you not to return to your primary residence, you must find an alternate residence if you are released from custody, at least until your first hearing on the 18th. If you're released and you need to return to that location to retrieve any personal items, clothing, toiletries, anything you might have at that location, you can have 1 civil standby with local law enforcement. That means law enforcement can escort you back to that location 1 time between when you're released and your first hearing to retrieve anything you might need in that time period. If you need to do that, please call the non-emergency number to any local police agency. Comply with whatever their terms are in regards to getting an officer to take you to that location. Please know, Mr. Colarusso, I am not permanently ordering, I'm not ordering it for the ever you can't go back to that location, just that at least until you see the judge on the underlying facts on the 18th, if you're out of custody, you can't go back there except for that 1 time with law enforcement.
What's today's date?
I'm sorry?
Today's date?
Is the 12th. Okay, also, if you are released from custody, upon release, you cannot possess weapons or possess or consume any alcohol or drugs without a valid prescription. Do you have questions about these release conditions?
No.
Okay, thank you very much. You can step back and get your paperwork.
I don't have my wallet, I don't have my credit cards, I don't have anything.
Are those at the location or were they impounded when you were? So call when you get out or before you get out of here, get a hold of local law enforcement and tell them that you need to go back to that location, get an officer to take you back there to retrieve all of that stuff.
Okay, thank you.
Okay, thank you, Mr. Colarusso. Okay, Ray Lujan, if you would work your way into the courtroom, please. Gabriel Gonzalez, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
Ray Lujan, 9/11/74.
Thank you, Mr. Lujan. You are here on a bench warrant issued by the Superior Court when you failed to appear at a status conference in an existing felony drug case. You have a lawyer already assigned to you in that case. I am aware that your lawyer has filed a motion to quash that warrant. Unfortunately, you were picked up on it before the court had an opportunity to rule on it. So when you were arrested, it was a valid warrant. Your next court hearing is already set in this case. That hearing, there was a hearing on the motion to quash set March 18th at 10:15. So I am just matching that hearing. That will be your next court hearing out of this court as well. So you just have to go back to the trial judge one time. It'll be the 18th at 10:15. The trial... What? Let me finish first, and then I'll let you. The trial court has asked for a $1,000 secured appearance bond as a result of that first failure to appear. It sounds like you've made some efforts to try to resolve that, so I've cut that in half. I've put a $500 secured appearance bond on that warrant because you did miss that hearing. You did get picked up on that warrant, which was valid at the time. So you will have to post a $500 bond to secure your release from custody, but your next court hearing is the one that was already set. What is it that you'd like to say? Proceed with caution because you don't have your lawyer here.
Okay, no. I went to court. I just showed up late.
Yeah.
I was late because I have to take the bus all the way from Chandler over here because I don't have a vehicle.
So unfortunately, when you don't appear at the scheduled time for it doesn't matter whether you're late or you're not there at all. If you're not there when the judge calls your hearing, it's a failure to appear, regardless of whether you show up 1 minute later or you never come at all. So when you have this hearing on the 18th, it looks like it's a little bit later in the day. So. Yeah, if you post that bond and you're released, instead of your hearing being at 8:30, it's going to be at 10:15. So I would say do whatever you have to do to try and catch an earlier bus or see if you can secure a ride or something so that you're there on time.
Yeah, I caught the first bus, the very first bus I caught, and it's just the way it is. I mean, they take long to get there.
Maybe you could avoid the bus. I don't know if that's an option for you, but if you could find somebody that could get you there, or you have an extra hour and 45 minutes.
Yeah, I had a ride, but it fell through.
Okay. All right. Thank you, Mr. Lujan. Joanna Morales to the podium in the courtroom, please. Brooklyn Burrows, if you would please work your way to the second chair.
Juana Morales, 12-2-2-5.
Thank you, Ms. Morales. You are here on 2 probation violation warrants. In both cases, petitions to revoke your probation were filed. They allege you have violated terms 3 and 5. I have appointed a lawyer to represent you in both probation cases. Your next court hearing will be a revocation arraignment March 19th at 8:30 in the probation court downtown. On these 2 warrants, you have a total secured appearance bond of $600. It's $500 on one of the warrants, $100 on the second. So total $600, all secured appearance. If you post that and you're released from custody, you cannot possess any weapons or any drugs without a valid prescription. Do you understand those conditions? Okay, thank you very much. You can step back and get your paperwork. Gabriel Gonzalez to the podium in the courtroom, please. Arturo Rodriguez, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Gabriel Gonzalez, 2998.
Thank you, Mr. Gonzalez. You are here on a probation violation warrant. A petition to revoke your probation was filed. It alleges that you have violated terms 3 and 5. I have appointed a lawyer to defend you in the probation proceedings. Your next court hearing will be a revocation arraignment March 19th. It'll be at 8:30 in the Superior Court downtown. On that warrant, you have a $250 secured appearance bond. If you post that bond and you're released from custody, you are ordered not to possess any weapons or any drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay, thank you. You can step back and get your paperwork. Brooklyn Burrows to the podium in the courtroom, please. Joshua Kirby, if you would please work your way to the second chair. Can I have your name and date of birth, please?
Brooklyn Faith Burrows, April 29th, 1994.
Thank you, Ms. Burrows. You are here on 3 different matters. The first matter that you're here on is an arrest warrant issued after a direct complaint was filed. A direct complaint is a written document that alleges new allegations against you. In this direct complaint, those allegations are 1 count of narcotic drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of false reporting to law enforcement, a Class 1 misdemeanor. Those allegations are alleged to have been committed November 3rd of 2024. I have appointed a lawyer to defend you against those allegations, and your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th, both of them at 8:30 in the Superior Court downtown. The other two matters you're here on are allegations that the new charges in that direct complaint violated term 1 of your probation in 2 different cases. In both of those probation cases, I've appointed a lawyer to defend you. Your next court hearing in each of the probation matters will be a revocation arraignment March 19th at 8:30 in the Superior Court downtown. On each of these 3 cases, you have a $250 secured appearance bond. That means your total bond will be $750. It is all secured appearance. If you post that and you're released from custody, you cannot possess any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Ms. Burrows. You can step back and get your paperwork. Arturo Rodriguez to the podium in the courtroom, please. Michael Garcia, if I could ask you to please work your way to the second chair. Can I have your name and date of birth, please?
Arturo Rodriguez, September 23rd, 1985.
Thank you, Mr. Rodriguez. You are here on 2 different matters. The first matter that you're here on is an arrest warrant issued after a direct complaint was filed. That direct complaint is a written document that alleges new allegations against you. The allegations in that direct complaint are 2 counts of aggravated driving under the influence, both Class 4 felonies, both alleged to have been committed January 21st of 2024. I have appointed a lawyer to defend you against those allegations. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th, both of those at 8:30 in the Superior Court downtown. On that direct complaint, you have a $250 secured appearance bond. The second matter that you're here on is a failure to appear warrant issued by the Surprise Municipal Court. That one is on a misdemeanor driving under the influence case. I am not making any orders regarding your entitlement to a court-appointed lawyer in the misdemeanor DUI case. Those orders will be made by the surprise judge. So if you have a court-appointed lawyer, that lawyer will continue to work with you. If you don't have one, but you think you're entitled to one, please talk to the surprise judge about that at your next court hearing. That hearing will be an arraignment hearing March 18th. It'll be at 1:30 in the afternoon. So same date as your first hearing on the felony, but it'll be in the afternoon, not the morning. Okay, on the misdemeanor warrant, you have a $50 secured appearance bond. So your total bond will be $300. It is all secured appearance. If you post that and you're released from custody, you cannot possess or consume any alcohol or drugs without a valid prescription. And if you're released, you cannot operate a motor vehicle if you don't have a valid driver's license. Do you understand those conditions?
Yes, ma'am.
Okay, thank you very much. You can step back and get your paperwork. Joshua Kirby, if I could ask you to work your way into the courtroom, please. Pedro Serrano, can I have you work your way to the second chair?
My name is Joshua Kirby.
Hold on 1 second. Wait till you're at the podium. All right, go ahead.
Joshua Kirby.
And what's your date of birth, Mr. Kirby?
4/20/47.
Thank you very much. You are here on an arrest warrant issued after a direct complaint was filed alleging new allegations against you. The allegations in that direct complaint are 1 count of narcotic drug possession, a Class 4 felony, and 1 count of drug paraphernalia possession, a Class 6 felony. That direct complaint alleges both of those offenses were committed July 28th of 2024. I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 27th and then a preliminary hearing March 31st, both of them at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services, so you will be out of custody. You don't need to post a bond, but once you are out, in addition to getting yourself to your next court hearings, you'll also be required to make contact with pretrial services. Their contact information will be in a packet you get with your release order, so please keep that. Once you're out of custody, you also cannot possess any drugs without a valid prescription. Do you understand those conditions?
Yes.
Okay, thank you, Mr. Kirby. You can work your way back to your left. Michael Garcia, if you would work your way into the courtroom, please. Lorenzo Gastello, if I could ask you to work your way to the second chair. Can I have your name and date of birth, please, sir?
Yes, Garcia Michael, 22586.
Okay, thank you very much, Mr. Garcia. You are here on an allegation of a new charge. That allegation is 1 count of theft or being in control of stolen property. It is a Class 6 felony. I have found probable cause to support that allegation, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 27th and then a preliminary hearing the 31st. Both of them will be at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services, so you will be released from custody. You don't need to post a bond, but once you are out of custody, you will be responsible for getting yourself to both of those court hearings, and you'll be required to make contact with pretrial services. So with your release order, you'll get a packet that has their contact information in there. Please keep it and use it as soon as you're out to make contact with them. Also, once you're out of custody, you cannot return to the scene where the alleged theft took place, and you cannot have contact with any alleged witnesses. You also cannot possess any drugs without a valid prescription.
Okay.
Do you understand those conditions?
Just really quick, I know when I was taken into custody, my vehicle's still there. The officers talked to the people, the security said that I was able to just get my car and leave instead.
Oh, it's at the location where the alleged theft took place?
Yeah.
Okay, so here's what I'll do. I will put an order, I'll make one exception to the order that you not go back there. I will allow you to go back there one time in order to retrieve your personal vehicle.
Okay. Yeah, okay, thank you.
Okay.
Also, Your Honor, with the pre-trial, do I have so many, like, I have to contact him, like, with as soon as I get out?
Yeah, I think technically you have 72 hours to contact them, but you might as well, they're open normal business hours, so from 8 to 5, Monday through Friday. You might as well just make that call today as soon as you get out so it's out of the way and you don't forget to do it.
Yeah.
Because if you forget, it could be a violation of these release conditions and you don't want that.
No.
Okay, anything else?
No.
All right, we will get that paperwork the corrected paperwork reprinted, and we'll bring it out to you if you want to step back to your left.
Okay, awesome. Thank you.
Sure. Okay, Mr. Serrano, if you'll stay in the chair for one quick second, I need to take one quick break, and then we'll be right back. Okay, my apologies for that delay. Thank you for your patience. Can I please have Pedro Serrano into the courtroom? Alyssa Gonzalez, if you would please work your way to the second chair. You just do his job. Can I have your name and date of birth?
Pedro Berdanino Serrano, 4/12/1983.
Thank you very much. Okay, Mr. Serrano, you are here on allegations of new charges. The allegations against you are 1 count of dangerous drug possession, a Class 4 felony, 1 count of drug paraphernalia possession, a Class 6 felony, and 1 count of criminal trespassing. That one's a Class 3 misdemeanor. I did find probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 27th and a preliminary hearing March 31st, both of them at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services. So similar situation I've talked to not everybody, but the last couple people about. You're going to be released from custody. You don't need to post a bond, but once you are out of custody, you will be required to contact pretrial services. Their information will be in a packet that you get with your release order, so please keep that. Once you're out, open that packet, give them a call. Also, once you're out of custody, you cannot return to the scene where the alleged trespassing took place, and you cannot have any drugs without a valid prescription.
I will.
Do you understand those conditions?
Yes, I do.
Okay, thank you, Mr. Serrano. You can step back and get your paperwork. Lorenzo Costello to the podium in the courtroom, please. Good morning, sir. Can I have your name and date of birth?
Lorenzo Costello, 4/21/89.
Thank you, Mr. Costello. You are here on allegations of new charges. The allegations against you are 1 count of being a passenger in a means of transportation obtained unlawfully. That is a Class 6 felony. 1 count of being in possession of prescription drugs without a valid prescription, and 1 count of drug paraphernalia possession. Those last 2 are Class 1 misdemeanors. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 27th and a preliminary hearing March 31st. Both of them will be at 8:30 in the Superior Court downtown. I am releasing you to the supervision of pretrial services, so you will be released. You don't need to post a bond, but once you're out, you will be responsible for getting yourself to your next 2 court hearings. You'll also be required to contact pretrial services. So with the packet you get with your release order, their information will be in there. As soon as you're released from custody, please open that packet, use the information in that packet to call pretrial. Also, once you're out of custody, you cannot go back to the scene where the alleged vehicle was stolen. You also can't have contact with any alleged victims or witnesses or co-defendants of that offense, and you cannot possess any drugs without a valid prescription upon release. Do you understand those conditions?
Yeah.
Okay, thank you, sir. You can step back and get your paperwork. Alyssa Gonzalez to the podium in the courtroom, please. Ash, can you talk to the clerk for a second, please? Can I have your name and date of birth?
Alyssa Gonzalez, 11/26/1999.
Thank you very much, Ms. Gonzalez. You are here on 2 different matters. The first matter that you're here on is an allegation of a new charge. That allegation is 1 count of criminal trespassing in a residential yard. It is a Class 1 misdemeanor. I have found probable cause to support that allegation. I've also determined you are entitled to a court-appointed lawyer, but that lawyer is going to be appointed for you by the next judge you see at your next court hearing. That hearing will be an arraignment hearing April 1st. It'll be at 9 o'clock in the Peoria Municipal Court. The second matter that you're here on is an allegation that that new misdemeanor offense violated term 1 of your probation. In the probation matter, I've appointed a lawyer to represent you. Your next court hearing in that probation case will be a revocation arraignment March 19th at 8:30, that one in the Superior Court downtown. On both of these matters, I am releasing you on your own recognizance, so that means you're going to be released from custody. You don't need to post a bond. Once you are out of custody, you are ordered not to return to the scene where the alleged trespassing took place. My understanding, based on the information law enforcement provided to me, is that you might have personal items at that location that you're trying to retrieve. So here's the deal. If you contact law enforcement and get permission to have an officer take you back to that location, you can go there to retrieve your property, but you cannot go back there unless you're accompanied by a law enforcement officer. Also, once you're out of custody, you can't possess any weapons or drugs without a valid prescription. Do you understand all of those conditions?
Yes.
Okay. Do you have a question?
No.
Oh, okay. Thank you then. You can step back and get your paperwork. Okay, Victoria Martinez, if I could ask you to work your way back into the courtroom, please. All right, if you'll give me your name and date of birth one more time, please.
Victoria Martinez, 9/14/91.
Okay, thank you very much, Ms. Martinez. All right, we were talking about a warrant, a failure to appear warrant issued by the Gila County Superior Court in a felony case involving possession of burglary tools. You had indicated to me that it was your understanding that warrant had been resolved or quashed. Since I first saw you and now my clerk has been able to contact the Gila County Attorney's Office, they have confirmed that there was some sort of Gila County Justice Court or Municipal Court case that was resolved, but the felony case in Superior Court has not been resolved. So they did confirm again that that is a valid warrant. It looks like there was a hearing held February 5th in the felony case that you were not present for, and that's when the court issued that warrant. So it is a valid warrant. You have a $2,500 secured appearance bond on that Gila County felony warrant. Your next hearing on that warrant will be March 17th at 8:30 in the Gila County Superior Court. Okay, the second matter that you're here on is an allegation of a new offense committed here in Maricopa County. That allegation is 1 count of narcotic drug possession. It's a Class 4 felony. I did not find probable cause to support that allegation. So what that means is I am not imposing any release conditions or bond amounts or anything like that on you on that new allegation. I will tell you though, Ms. Martinez, that my finding of no probable cause doesn't mean that allegation is legally dismissed. It is possible that the county attorney's office will file charges on that. If that happens, I've appointed a lawyer that will defend you. You also have court hearing dates that you'll have to attend on this new allegation. So you will have to attend a status conference March 27th and then a preliminary hearing the 31st. When you go to court on the 27th, the court might tell you nothing has been filed and you don't have to go back on the 31st. But if you do not go to court on the 27th and the county attorney's office has filed charges, that court's going to issue a warrant for your arrest.
For the one here?
That's the Maricopa County one, yeah. So you have your court hearing in Gila County on the 17th. If you post the $2,500 bond, you'll be out of custody. You have to get yourself up to Gila County. If you don't post that bond, you'll stay in custody and be transported for that hearing. Then after you see the judge in Gila County on the 17th, don't forget that on the 27th, you have to be back in the Maricopa County Superior Court at 8:30 for your possible hearing on that new allegation if a charge was filed.
Okay. Is there any way it could be lowered? I have like about $400.
The bond on the Gila County?
Yeah.
I can't lower it because I'm not the judge or not sitting in the court that issued that warrant. So only Gila County could lower that. And you could try to get a hold of a lawyer to get a motion before the Gila County judge to lower that bond, but I doubt that you would get anything, you would hear anything on that prior to your hearing on the 17th.
Okay. Because I just don't understand why they didn't bring it up when I went in August to get it quashed.
Well, first of all, because it was a different court. So it looks like the warrant that was issued in the municipal or misdemeanor case is a different court than the Superior Court. But also it looks, you mean this was issued, it would have been before, because you're talking about August 2024, right? Yeah. So probably because it was a different court and the court that you were in dealing with that warrant didn't run a warrant check to find the Superior Court warrant. That would be my best guess, but I don't know for sure. Okay. Any other questions?
No.
Okay. Thank you very much for your patience and letting me look into that. If you'll step back to your left.
So the 17th, I have court up there?
That's right.
Are they going to come get me or?
Yes.
Okay.
All right. What do you want me to do now?
Let's see, we have Hector here, right?
Okay. Hector Fausto Najera. All right. If you'll come on into the courtroom, please. Can I have your name and date of birth, please?
My name is Hector Fausto Najera. Date of birth, 05, May 6, 2006.
Okay, thank you very much, Mr. Fausto Najera. You are here on allegations of new charges. The allegations against you are one count of conspiracy to commit discharging a firearm at a residence, a Class 2 felony, one count of discharging a firearm at a residence, also a Class 2 felony, one count of conspiracy to commit discharging a firearm at a non-residence, that's a Class 3 felony, and one count of discharging a firearm at a non-residence, also a Class 3 felony. I have found probable cause to support those allegations, and I've appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. Both of those hearings will be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $1 million secured appearance bond. If you post that bond prior to your release from custody, you will be affixed with an ankle monitor. If you post that bond and you are released on that ankle monitor, you cannot return to the scene where any of the underlying allegations took place. You cannot have contact with any alleged victims, witnesses, or co-defendants. You also cannot possess any weapons, drugs without a valid prescription, or consume any alcohol if you're released from custody. Do you understand those conditions?
Yes, ma'am.
Okay, thank you very much. You can step. Yeah.
The bond, you said how much?
It's a $1 million secured appearance bond.
And it has to be paid in full?
Well, the bond has to be received in full by the court, but it is secured appearance, so you could use a bonding company to post it.
And wait, can you say that again?
Sure. The bond amount has to be posted in full to the court, but you could use a bonding company to post that bond. So bonding companies typically require you to pay less than the full amount up front, but they have other requirements too. So if you want to look into using a bonding company to post that bond, back in the jail facility, there's a list of bonding companies and their phone numbers posted in places. You can find one of those or ask jail staff to get a list for you. They could get you a list of bonding companies. You can use any of the phones back there to call 1, 2, or all of those companies if you want to.
Okay.
Any other questions?
Yeah, can you, I wanted to ask you something. Can I get a phone number off my phone? You have
to talk to jail staff about that. I don't know.
I don't know no phone number.
I don't know what their policies are. I don't know where your phone is. I don't know if law enforcement has it. I don't know if MCSO has it. So tell MCSO you want phone numbers off your phone. If that's possible, they can help you work that out, or they can tell you that that's not an option. I don't have control over that. Okay, thank you very much. You can step back and get your paperwork. Other way, come, yep, right back where you came from.
You're gonna go back to your stuff. Going back? Yeah, a lot of them need to go. Did you want to see Newman?
Newman?
931.
I don't have her. It looks like she was moved.
Oh, she was moved?
I don't know, but she's not on this docket.
Oh.
Let me see.
29 and 31?
She's on the 2.
She's on the 2? Okay.
Yeah.
Let me fix that. How about, can we do?
I have 433 and 1 left.
Yeah, what?
Yeah, we could accept.
No.
No, we could except we can't.
Yeah. Okay.
We can just wait. We'll just hang out. I'll read the house call. How about that?
Yeah.
Okay. Number 26 on the calendar, Daniel Ulysses Moreno, date of birth 8/23/88, is not in the courtroom because
he's combative and suicidal.
Combative and a danger to himself. He is here on allegations of new charges. The allegations against him are 1 count of criminal trespassing, a Class 6 felony, and 1 count of disorderly conduct, a Class 1 misdemeanor. I have found probable cause to support those allegations, and I have appointed a lawyer to defend him. His next court hearings will be a status conference March 18th and then a preliminary hearing March 20th. Both of them will be at 8:30 in the Superior Court downtown. I have imposed a $15,000 secured appearance bond on those allegations. If anything changes after I visit Mr. Moreno's cell site, I will update this recording. What's the sitch?
They're all kind of the same thing.
Well, come here.
Do you want to talk this? Don't take it around, yeah.
Well, I called your name and I said, "Ah, but then you said, "Wanna know what it is?" I have Victoria, what is it?
I just wanted them individually sold.
No. I just wanted everybody but the 3 of them.
Okay, yeah, we're good with that. Yeah, because I brought the guy in too.
Explain all of that. Are we good? Okay, Sonny Jefferson, can I ask you to work your way into the courtroom, please? Ben Koo, you'll be next. Gabriel Carr, you'll be last. You guys can stay where you are. If you want to, you can move to the chairs. There's so few of you, I'm not worried about where you are now. Okay, can I have your name and date of birth, please, sir?
Sonny Jefferson, 11/18/78.
Thank you very much, Mr. Jefferson. You are here on 2 different matters. The first matter that you're here on is a grand jury warrant. In that case, a state grand jury was convened and found probable cause to return an indictment against you. The counts of that indictment are 5 counts of voyeurism, all Class 5 felonies, and 1 count of kidnapping, a Class 2 felony. I have appointed a lawyer to defend you against the allegations in that grand jury warrant. Your next hearing on that case will be an arraignment hearing March 19th. It'll be at 8:30 in the Superior Court downtown. On that grand jury warrant, you have a $50,000 secured appearance bond. Arizona law requires that if you post that bond, you be affixed with an ankle monitor prior to your release from custody. The second matter that you're here on is an allegation of a new offense. That allegation is 1 count of dangerous drug possession, a Class 4 felony. I did find probable cause to support that allegation, and I've appointed a lawyer to defend you. Your next court hearings on that drug allegation will be a status conference March 18th and then a preliminary hearing March 20th, both of them at 8:30 in the Superior Court downtown. On the drug allegation, you have a $500 secured appearance bond. So your total bond for these 2 cases will be $50,500. It is all secured appearance. If you post that and you are released on that ankle monitor, you cannot have contact with any alleged victims or witnesses of any of the underlying offenses, and you cannot possess any weapons or drugs without a valid prescription. Do you understand those conditions?
Yes, ma'am.
Okay.
like, I never got nothing contacted me about the warrant.
Yeah, you wouldn't have. So in Arizona, grand jury proceedings are secret. So you find out that a grand jury has issued an indictment against you because you're picked up on the warrant. That's how the process works.
So I got stopped, and they never stated that to me at all.
It doesn't matter. I just told you. So I just told you have a grand jury indictment.
Okay, but
that's the purpose of this hearing.
I don't know how that works. Like, I don't comprehend. I don't comprehend it. I don't know.
What are you not comprehending?
Like, how? I don't know what's going on, really.
What's going on is a grand jury has issued an indictment that charges you with new allegations. So the purpose of this hearing is for me to tell you you have this grand jury indictment. I've given you a lawyer to defend you in that case. So at your next hearing, you can talk to your lawyer. Your lawyer can go over the procedural history with you and explain to you how it got to this point, and can talk to you about the factual presentation made to the grand jury.
And kidnapping?
I'm sorry?
And kidnapping? I've never...
Yeah, it looks like the grand jury warrant is 1 count of kidnapping, 5 counts of voyeurism. I don't know what the underlying factual allegations are. Those facts were given to the grand jury. So that's why I'm saying you'll have to go to your next hearing and talk to your lawyer.
So I can't get released?
Not unless you post that bond. All right. Thank you, Mr. Jefferson. You can step back to your left. Ash. All the way. Okay, I'm sorry. Can I have Ben Koo into the courtroom, please?
Good morning.
Good morning. Can I have your name and date of birth, please?
Ben Koo, 10/6/1966.
Thank you very much, Mr. Koo. You are here on allegations of new charges. The allegations against you are 1 count of pandering, 1 count of inducing prostitution, and 1 count of maintaining a house of prostitution. All of them are Class 5 felonies. I have found probable cause to support those allegations, and I have appointed a lawyer to defend you. Your next court hearings will be a status conference March 18th, and then a preliminary hearing March 20th. Both of them will be at 8:30 in the Superior Court downtown. On these allegations, I have imposed a $500,000 secured appearance bond. If you post that bond and you are released from custody, you cannot have contact with any alleged victims, witnesses of the underlying allegations. You cannot possess any drugs without a valid prescription. And whether or not you are released from custody, you are ordered to strictly comply with the terms of any orders of protection or orders against harassment that have been or might later be served upon you. Do you understand those conditions?
Yes, ma'am.
Okay, thank you very much. You can step back to your left.
Thank you.
You want them all the way out? Yes, please. Okay, Gabriel Carr, if I could ask you to work your way into the courtroom, please. Can I have your name and date of birth, please?
Gabriel Carr, 07/20/2001.
Thank you very much, Mr. Carr. You are here on a grand jury warrant. A state grand jury was convened and found probable cause to return an indictment against you. That indictment contains 10 counts of sexual exploitation of a minor, all Class 2 felonies. I have appointed a lawyer to defend you against those allegations. Your next court hearing will be an arraignment hearing March 19th at 8:30 in the Superior Court downtown. On that warrant, you have a $150,000 cash-only bond. If you post that bond, Arizona law requires that you be affixed with an ankle monitor prior to your release from custody. If you post that bond and you are released on that ankle monitor, you are ordered not to have contact with any minors. You cannot access the internet through any electronic means, and you cannot possess any drugs without a valid prescription. Do you understand those conditions?
Yeah.
Okay, thank you very much, Mr. Carr. You can step back and get your paperwork. Okay, this court will stand in recess until 2 p.m.
What's going to happen?
All right.
Thank you. Please be seated. Do you have a trigger? Were you trying to call me when you were ready?
Yes, I can find that.
Wait, that's one. All right. Good afternoon, everyone. This is the 2 p.m. initial appearance calendar for March 12th, 2025. The court's orders for the taking of DNA and fingerprints that were issued on the first calendar of this month shall apply to all matters on this calendar. My name is Commissioner Lacey Fisher. In a moment, I will call each one of you up to the lectern one at a time to let you know why you're here and whether or not you'll be released. Please keep in mind a couple of things. First, you have the right to remain silent. Anything you say during this proceeding could be used against you in your case. Second, you have the right to counsel. Most of you have qualified for a court-appointed attorney. I'm sure you have a lot of questions about your case. The person you need to speak with is your lawyer. I can't give you legal advice. Finally, I'm going to be giving you a lot of important information during your hearing, including telling you your next court date. Everything that I tell you during your hearing, including those court dates, will be in the written paperwork the officers give you at the end of your hearing. So please hold on to that paperwork. It will be very important. All right. And then, counsel, you're here for Mr. Leyva Rubio?
Yes, Your Honor.
All right. Does state counsel know that we have an attorney here?
He does know. He hasn't responded with the form yet.
Okay. Is he planning to come?
He hasn't responded.
Okay. Let's give the county attorney a minute to determine whether they want to appear since you're here. And then they did file a written recommendation. Have you seen a copy of that?
I have not, Your Honor.
Okay, we'll try and get you a copy of the written recommendation, and then it sounds like they're going to try and get you a copy of the Form 4.
Okay.
Because I'm not sure if it needs to be redacted or anything like that for victim info. So if you don't mind hanging tight, we'll hopefully get to you as soon as we can. Joshua Miller, please, and then Elijah Green to the chair by the door, please. Miller?
Miller. Come on.
All right, good afternoon, sir. Please tell me your full name and your date of birth.
Joshua Tyler Miller, 5/13/96.
Thank you, sir. I have you here on a new case. You were arrested on one allegation of possession of narcotic drugs, a Class 4 felony, and one allegation of possession of drug paraphernalia, a Class 6 felony. I have found probable cause to support those allegations, and I'm appointing you an attorney. You'll have court on March 18th and March 20th at 8:30 in the morning in the downtown Superior Court. Because it's alleged these offenses occurred while you were on pretrial felony release in CR 2022-111209, by law you must remain in custody without bail. I am setting a bail eligibility hearing for you on March 19th at 1:30 in the afternoon. You're also here on that other matter ending in 309 for failing to appear at your court date. In that matter, you have court on March 18th at 8:30 in the morning, and you have a $2,500 secured appearance bond. Even though you have a bond in that matter, because you're currently being held without bail in your new case, if you post the bond in that matter today, you will not get released from custody. The only thing that will happen is you won't get credit for the days you are serving in custody on those matters. Do you understand everything I've told you, sir? Do you have any questions? All right, go ahead and step to your left, sir. That'll conclude your hearing. I re-signed. It's 29, but we don't have to re-sign it. Elijah Green, please, and then we'll see Tiandra Grimes to the chair by the door, please. We can get Grimes to the chair, please. There we go. All right, good afternoon. Please tell me your full name and your date of birth.
Elisha Scott Green, 08/12/2003.
Thank you. I have you here on a new case. You were arrested on one allegation of possession of dangerous drugs, a Class 4 felony, one allegation of possession of drug paraphernalia, a Class 6 felony, one allegation of false reporting, a Class 1 misdemeanor, and 2 allegations of criminal trespassing, Class 3 misdemeanors. I have found probable cause to support those allegations, and I'm appointing you an attorney. You'll have court on March 18th and March 20th at 8:30 in the morning in the downtown Superior Court. Because it's alleged that this offense occurred while you were on pretrial felony release in CR 2024-155730, by law you must, 2024-155573-001, by law you must remain in custody without bail. I am setting a bail eligibility hearing for you on March 19th at 1:30 in the afternoon. You're also here on that other matter ending in 573 for failing to appear at your court date. In that matter, you'll have court on March 18th and March 20th at 8:30 in the morning in the downtown Superior Court, and you have a $500 secured appearance bond. Even though you have a bond in that case, because you're currently being held without bail in your new matter, if you pay that bond today, you will not get released from custody. The only thing that will happen is you won't get credit for the days you are serving in custody on that case. Do you understand everything I've told you?
Yes.
Do you have any questions?
No.
All right, thank you. You can step to your left. Tiandra Grimes and then Gabriel Reyes to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
Tiandra Nicole Grimes, June 16, 1981.
Thank you. I have you here on a warrant out of another county. It's out of Graham County Superior Court for an alleged aggravated assault with a deadly weapon or dangerous instrument. To the extent that one has not already been assigned to you, I am appointing you counsel pursuant to Rule 6.1, and you'll have court on March 17th at 8:30 in the morning in the Graham County Superior Court. I'm affirming the bond amount that is listed on the warrant, which is a $10,000 cash-only bond. I'm also ordering that you comply with all of the written instructions in your paperwork. It's going to include that you're not to have contact with any alleged victim or witness. You're not to possess any weapons. You must obey any terms of any orders of protection that have been issued or may be issued. You are not to return to the scene of any alleged crime. All of that information will be in the written paperwork you received. Do you understand everything I've told you?
Yes, ma'am.
Any questions?
No.
All right, we have to reprint her paperwork, so go ahead and step to your left, and they'll bring you an updated copy in just a minute. Gabriel Reyes, please, and then Walter Kaut to the chair by the door, please.
Hello.
Hello, my name is Gabriel Ruben Reyes, date of birth 11/28/1998.
Thank you, sir. All right, I have you here on a warrant for alleged probation violation matter. In that case, I'm appointing you a lawyer, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. You have a $10,000 secured appearance bond in that matter, and I'm ordering that you comply with all of the written instructions in your paperwork. Actually, hold on 1 second. And then you're also here on 2 warrants. Looks like they're both out of the East Mesa Justice Court. One is for excessive speeding. Actually, they're both for excessive speeding matters. In each of those cases, I'm appointing you a lawyer. You'll have court on March 17th at 8:30 in the morning in the East Mesa Justice Court. And in each of those matters, you have a $50 secured appearance bond. In all, or in total, then, your total bond will be $10,100 secured appearance. And I'm also ordering you comply with all of the written orders in your paperwork that will include that should you post your bond and be released, you need to contact your probation officer within 24 hours of your release from custody. Do you understand everything I've told you?
Yes, ma'am. The only question I have is, are you able to reduce my bond for the probation? Because I'm eligible to bond out, but I don't have that much, and collateral as well. And if you could do me that favor, I really, really appreciate it, because on the 18th, I have a son to be born at 6 in the morning on Higley and 60 at the Banner Hospital. Mm-hmm. And I really want to be there, because, it's my first child. I want to be there. I want to, experience that of a man to be there for his son, because when I was growing up, my dad was never there. He was a deadbeat. He was, you know what I mean? He was out of the picture, and I'm trying to break the circle on my part. I'm gonna be there, sign this birth certificate, everything else, and move on forward with my life. But this bump in the road, is just messing me up with that.
All right. How long have you known that your significant other was pregnant?
I've been knowing. We probably found out in November.
Okay. So a lot of your violations are since then. To be quite frank, if I had, I'm affirming the bond that your judge set. If it were up to me, I probably would have set a higher bond. You're on probation for very serious offenses, for a class 3 aggravated assault with a deadly weapon or dangerous instrument and domestic violence offense.
Yes.
And you're on intensive supervised probation, and they're alleging that you didn't comply in multiple different ways. So I'm not going to reduce your bond at this time. I do appreciate that you want to be in your child's life, but part of that is going to be on you working and complying with probation.
Yes, correct.
All right. Any other questions?
Another question. When if I'm able to bond out, do I just go probation, call and check in, everything else, how everything should have been before?
Right. So you're going to need to call them within 24 hours of your release from custody. If you don't, another warrant can issue for your arrest.
Yes.
And then you need to go to your court date.
Yes.
All right. Any other questions?
One more. I'm sorry.
No, that's okay.
For the 10,000, is it cash or can I bring collateral?
You can use collateral.
Okay. That's all I wanted to ask.
All right. No problem. Any other questions?
No, ma'am.
All right. Thanks,
Have
everyone.
a good day. Thank
you. You as well. All right. And counsel, it sounds like we've connected with the county attorney. He is not wishing to appear, and were we able to give him a phone for? Okay. So whenever you're ready, counsel, for your matter, I am ready. Okay. Then let's see Mr. Edwin Yeva Rubio. And then after Mr. Rubio, it's going to be Walter Couts, please. All right. This is number 33 on the calendar. Edwin Rubio. I'll take appearances from defense counsel.
Thank you, Your Honor. Michael Bernays on behalf of Mr. Rubio, who is present in custody.
Thank you. And then just so the record is clear, my courtroom assistant did reach out to Mr. Garcia, who is the deputy county attorney on this matter, and he is waiving his presence. He did file a written recommendation. Mr. Rubio, please tell me your full name and your date of birth.
Edwin Leyva Rubio, August 3rd, 2006.
Thank you. All right. Sir, you're here on a new case. You were arrested on one allegation of discharging a firearm non-residence as a Class 2 felony, 2 allegations of discharging a firearm at a non-residence as a Class 3 felony, and 3 allegations of discharging a firearm. I think those should all be the same. So those should all be Class 3 felonies, wouldn't you agree, counsel, the non-residence ones?
Judge, yes, all the non-resident ones should be the same classification.
Class 3.
I'm not intimately familiar with the statutes as to, but they should all be the same class.
Yeah, so I pulled up the statute. It looks like 13-1211 B is a person who knowingly discharges a firearm at a non-residential structure is guilty of a Class 3 felony. I'm guessing that's actually a typo in our system, but I will edit that and then just reflect that all of those should be Class 3 felonies. The arresting agency did put the correct subsection, so I think that's a computer glitch. Those should be Class 3. Let me make sure that's properly reflected.
I'm sure it'll get straightened out, Your Honor, as the case progresses, through either grand jury or preliminary hearings.
Absolutely. So, sir, I do have you here on 3 allegations of discharging a firearm at a non-residence. Those are all Class 3 felonies. And then 3 allegations of discharging a firearm at a residence, which are Class 2 felonies. I did review the Form 4 that was provided, as well as the form, as well as the addendum that was attached to the Form 4. First, just as it relates to probable cause, counsel, would you like to be heard?
No, Your Honor.
All right. I have found probable cause to support those allegations. Counsel, are you retained in full or just for the purposes of this hearing?
My understanding is we are retained in full, Your Honor. I don't know if I'm going to be the assigned attorney on it or if it's going to be assigned elsewhere within the office, but I'm given to understand that you are on board.
All right. Excellent. Then I will reflect you as counsel of record. All right. And then, counsel, you did get a chance to review the written recommendation by the state. Beyond that, I reviewed the defendant's criminal history. It doesn't look like he has any adult felony convictions or any misdemeanors. So would you like to be heard regarding release?
I would, Your Honor.
Go ahead.
Judge, we would ask you to set a bond that is both reasonable and secured. I think the state's request for $1 million cash is tantamount to holding him without bond. He's 18 years old. He's not working at this time. His family is stretched to hire us, and they're just, absolutely, I wouldn't be able to post $1 million cash. I was impressed with the discussion in the Form 4 that it appears that he was not an organizer or a planner of these events, but was merely recruited to come along, which I think is, something that the court could take into consideration in assessing his culpability and what the court should do in terms of setting bond. He lives with his mother. He's a United States citizen. He's born here in Maricopa County, lives with his mom on 49th Avenue in Indian School. He has 2 brothers and a sister, all of whom live there together. He does not, to my knowledge, have any prior adult criminal history and therefore no failures to appear. And we would ask the court to set a bond, perhaps, I understand it's a serious case, but $50,000 secured would be a pretty big chunk and very important to the family, and I think that you could rest assured that he would comply with all of your orders and any subsequent court orders. We would also be happy to have him supervised by pretrial services as an overlay on whatever bonds you do set.
Okay, thank you, counsel. All right, so in reviewing both the Arizona Constitution and Rule 7.2, when considering release conditions, the court has to consider many factors. In this case, I did consider the lack of criminal history, the defendant's ties to the community, the defendant's family support. However, the court has also considered the strength of the state's case, at least as the allegations present in the Form 4. It appears that the defendant made admissions to being involved in both of the shooting scenes. They also allegedly found the weapon that was used in these shootings. Additionally, the court has to consider the danger to the community. These allegations are incredibly serious. They allege that the defendant and his co-defendants made a plan to go to these locations to do a shooting, a drive-by shooting at these locations, essentially. Multiple rounds were fired. At least in one home, I believe they indicated that there were numerous people inside the home. The fact that no one was killed during this incident is incredibly fortunate. And then the court also has to consider risk of flight. Of course, the defendant doesn't have any prior failures to appear. He has cut ties to the community. However, these allegations are incredibly serious, and he would be facing significant mandatory prison time should he be convicted after trial. For all those reasons, I'm setting the bond in the amount of $750,000 secured appearance. I am also ordering that should that bond be posted, that an electronic ankle monitoring device be installed prior to release from custody, and that you be placed on house arrest under the supervision of pretrial services. I'm also ordering, sir, that you comply with all of the written orders in your paperwork. They're going to include that you are not to return to the scene of any alleged crime. You're not to have contact with any alleged victim, witness, or co-defendant. You're not to possess any weapons, and you must comply with all the other written orders in your paperwork. Your next court dates will be March 18th and March 20th. At 8:30 in the morning in the downtown Superior Court. Counsel, I don't have any control over those hearing dates, so assuming they go forward,
I was just about to ask, Your Honor, because I'm leaving the country on Saturday.
Okay, so yeah, I think you can probably reach, I can't change them in the computer, but I think you could probably reach out to that division. Is that EDC 4, do you know? Simon, Commissioner Simon, and see if you can get that moved. So, anything further from counsel?
Not at this time, Your Honor.
All right. We'll get you a copy of the release order printed out if you need a minute to chat with your counsel or your client. That's fine with me, as long as that's fine with him.
Very good.
All right. Thank you, counsel. Have a great day.
Thank you, Your Honor. Thank you for taking me up.
No problem. And then we'll have no problem. We'll have Walter Couch, please, and then Carlos Jacobs to the chair by the door, please.
Is this new or is it
yeah, reprinting. Sorry. Oh. All right. Good afternoon, sir. Please tell me your full name and your date of birth.
Walter Couch is 12/1/1981.
Thank you, sir. I have you here on a new case. You were arrested on one allegation of possession of dangerous drugs, a Class 4 felony. I have found probable cause to support those allegations, and I'm appointing you an attorney. You'll have court on March 18th and March 20th at 8:30 in the morning in the downtown Superior Court. You're also here on 2 probation violation matters. In each one of your probation cases, a Term 1 violation has been alleged. They're saying that this new arrest constitutes a violation of your probation. I'm appointing you a lawyer in those cases as well, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. In each of your probation cases, you have a $2,000 bond. In your new case, you have a $1,000 bond. So your total bond is $5,000 secured appearance. I'm also ordering that you comply with all of the written instructions in your paperwork. It's going to include that should you post your bond and be released, you need to contact your probation officer within 72 hours of your release from custody. Do you understand everything I've told you?
Yes, ma'am.
Any questions?
No, ma'am.
All right. Thank you, sir. You can step to your left. Carlos Jacobs and then Jessica Newman to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
My name is Carlos Nathaniel Jacobs, 92896.
Thank you. I have you here on a probation violation matter. A petition to revoke your probation has been filed. I'm appointing you an attorney, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. You have a $750 secured appearance bond, and I'm ordering that you comply with all of the written instructions in your paperwork. It's going to include that should you post your bond and be released, you need to contact your probation officer within 24 hours of your release from custody. Do you understand everything I've told you?
Is there any way my bond could be lowered? I have money on my books right now.
I'm not going to reduce your bond. You're currently on intensive probation, and they're alleging you weren't compliant. So I don't think it's appropriate to reduce your bond at this time. All right. Thanks, sir. Jessica Newman and then Sean Kleeman, please. Good afternoon. Please tell me your full name and your date of birth.
Jessica Newman, 6/11/77.
Thank you. I have you here on 3 probation violation matters. In each case, a petition to revoke your probation has been filed. I'm appointing you an attorney, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. In each case, you have a $500 bond, so your total bond is $1,500 secured appearance. I'm also ordering that you comply with all of the written instructions in your paperwork. It's going to include that should you post your bond and be released, you need to contact your probation officer within 72 hours if you're released from custody. Do you understand everything I've told you?
Yeah.
Any questions?
No.
All right, thanks very much. Then step to your left. Sean Kleeman, please. And then Aaron Zavala to the chair by the door, please. Good afternoon, sir. Please tell me your full name and your date of birth.
Sean Lee Kleeman, 3885.
Thank you, sir. I have you here on 3 probation violation matters. In each case, a petition to revoke your probation has been filed. I'm appointing you an attorney in each matter, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. In each matter, you have a $500 secured appearance bond. So your total bond is $1,500 secured appearance. I'm also ordering that you comply with all of the written instructions in your paperwork. It's going to include that should you post your bond and be released, you need to contact your probation officer within 72 hours of your release from custody. Do you understand everything I've told you, sir?
Yes, ma'am.
Any questions? All right, thanks, sir. You can step to your left. Aaron Zavala, and then Teresa Gonzalez to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
Aaron Javier Yanis Zavala, 114-1985.
95 or 85?
85.
All right. Thank you, sir. I have you here on a probation violation matter. A petition to revoke your probation has been filed. I'm appointing you an attorney, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. You have a $500 secured appearance bond, and I'm ordering that you comply with all of the written instructions in your paperwork. It's going to include that should you post your bond and be released, you need to contact your probation officer within 72 hours of your release from custody. Do you understand everything I've told you?
Yes, ma'am.
Any questions?
No.
All right, thank you. You can step to your left. Teresa Gonzalez and then Joshua Gusel to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
Teresa Anne-Marie Michelle Gonzalez, March 28, 1985.
Thank you. I have you here on a probation violation matter. A petition to revoke your probation has been filed. I'm appointing you an attorney, and you'll have court on March 19th at 8:30 in the morning in the downtown Superior Court. You have a $250 secured appearance bond, and I'm ordering that you comply with all of the written orders in your paperwork. It's going to include that should you post your bond and be released, you need to contact your probation officer within 72 hours of your release from custody. Do you understand everything I've told you?
Yeah.
Any questions?
No.
All right. Thank you very much. Joshua Gusel, and then Austin Enoch to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
Joshua Daniel Geasley, 12/15 of 1981.
Thank you, and I apologize for mispronouncing your name.
That's okay.
I have you here on a new case. You're arrested on one allegation of interfering with judicial proceedings, a Class 1 misdemeanor. I have found probable cause to support that allegation. I am appointing or ordering that an attorney be appointed for you at your next hearing, which will be March 26th at 1 o'clock in the afternoon in the Goodyear Municipal Court. I'm planning on releasing you on your own recognizance in this matter, which means I will release you as long as you promise to go to court and comply with the written orders in your paperwork. Those orders are going to include that you're not to return to the scene of the alleged crime or have any contact with any alleged victim or witness. You're not to possess any weapons, and you must obey, sir, any orders of protection that have been issued or may be issued. Any violation of this no victim contact order, even if the alleged victim wants to have contact with you, could constitute you being charged with a separate felony offense. I'll tell you, sir, that it is critical that you comply with these orders and that you comply with the order of protection. Otherwise, you could end up facing felony charges and some very serious consequences, even more serious than you're facing right now. Do you understand everything I've told you?
Yes, ma'am.
Do you promise to go to your court dates and comply with these orders?
I do.
All right. If you fail to appear or you fail to comply, a warrant can issue for your arrest. Do you have any questions for me?
No, ma'am.
All right. Thanks, sir. You can step to your left.
Thank you.
You're welcome. Austin Enoch, and then Shelley Glossett to the chair by the door, please.
Hello, my name is Austin Enoch, date of birth 2/24/1989.
Thank you, sir. I have you here on a new case. You're arrested on one allegation of shoplifting with an artifice, which is a class 4 felony. I have found probable cause to support those allegations, and I'm appointing you an attorney. You'll have court on March 27th and March 31st at 8:30 in the morning in the downtown Superior Court. I'm planning to release you on your own recognizance, which means I will release you as long as you promise to go to court and comply with all of the written orders in your paperwork. Those orders will include that you're not to return to the scene of any alleged crime or have contact with any alleged victim or witness. You're not to possess or consume any drugs or alcohol without a valid prescription. If you fail to comply or you fail to go to your court dates, a warrant can issue for your arrest. Do you promise to go to your court date?
Yes, Your Honor.
Thank you, sir. Do you have any questions?
No.
All right. Thanks, sir. Shelley Glossett, please, and then Cameron Naharia to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
Shelley Renee Glossop, March 2nd, 1979.
Thank you. I have you here on a new case. You were arrested on one allegation of possession of dangerous drugs, a class 4 felony, and one allegation of possession of drug paraphernalia, a class 6 felony. I have found probable cause to support those allegations, and I'm appointing you an attorney. You'll have court on March 27th and March 31st at 8:30 in the morning in the downtown Superior Court. I'm planning to release you on your own recognizance, which means I will release you as long as you promise to go to court and comply with all of the written instructions in your paperwork. If you fail to appear or you fail to comply, a warrant can issue for your arrest. Do you promise to go to your court date?
I promise.
Thank you. Do you have any questions?
No, ma'am.
All right. Thanks, ma'am. You can step to your left. Cameron, please, and then Casey Pointer to the chair by the door, please. Good afternoon. Please tell me your full name and your date of birth.
My name is Cameron Injaria, and I was born February 27th, 2007.
Thank you, sir. And I apologize for mispronouncing your last name.
Yes, it's Injaria.
Is that how you say it?
Yes, ma'am.
Okay. I have you here on a new case. You were arrested on one allegation of unlawful use of means of transportation as a passenger, which is a class 6 felony. I have found probable cause to support that allegation, so I'm appointing you a lawyer to assist you. You'll have court on March 27th and March 31st at 8:30 in the morning in the downtown Superior Court. I'm planning to release you on your own recognizance, which means I'll release you as long as you promise to go to court and comply with the written orders in your paperwork. Those orders will include that you're not to return to the scene of any alleged crime or have contact with any alleged victim, witness, or co-defendant. You're also not to possess any weapons. If you fail to comply or you fail to go to court, a warrant can issue for your arrest. Do you promise to go to your court date?
Yes, ma'am, I do.
Thank you, sir. Do you have any questions?
Yes, I do. So I have 2 court dates.
That's a great question. So your first court date is called a status conference. The second court date is a preliminary hearing. That might get changed after your first hearing. I don't know. But so for the time being, they're set on those dates. When you see your lawyer on the 27th, they'll be able to let you know when you need to come back next, okay? If you need to come back, okay?
Okay, and...
Yeah, so just keep that 27th date is the most important one right now, okay?
27th. Okay, and will my lawyer's information, the court-appointed attorney, will that be on the paperwork?
Yes, so the phone number for your lawyer will be on the paperwork, but it's for your lawyer's office. So it takes some time for your lawyer to get assigned. You can try and call them and see if they can connect you to your lawyer, but he or she will definitely be at your first hearing on the 27th.
And one more time, you said the first hearing is the 27th, and the 30th is the second hearing?
The 31st.
The 31st, okay.
All right, and all of that will be on your paperwork as well.
Okay.
All right, any other questions?
No, ma'am. I guess I have got my phone taken, and I kind of need my phone, like, to get home or just to make calls and everything. How can I, like, or when I get that back?
Right, so if it was impounded here, then you might get it when you get released. If your arresting agency impounded it, then you're going to have to talk to them. Your lawyer should be able to help you sort that out.
Okay, but like, I'm not gonna have no way to call anybody once I leave here or anything. Like, will I be able to use a phone or anything? Like,
so there's phones in the facility you can use to call someone before you get released. Oh, and outside it sounds like. So. Okay. All right, thanks, sir. Go ahead and set your last. Casey Pointer and then Alice Faya to the chair by the door, please.
You ready? Okay.
Oh, no problem.
Just stand by. And I'll have you actually go that way. You good? You don't have to sing? Yep, nope, we're all good. Thank you, Your Honor.
Take care. All right, good afternoon. Please tell me your full name and your date of birth.
Good afternoon. My name is Casey Pointer. My date of birth is June 22nd, 2003.
Thank you, sir. I have you here on a new case. You're arrested on one allegation of assault, a class 2 misdemeanor. I have found probable cause to support that allegation. Based on that financial affidavit that you provided, you don't qualify for a court-appointed lawyer, but you can retain your own attorney or represent yourself. You'll have court on March 31st at 9:30 in the morning in the Kyrene Justice Court. I'm planning to release you on your own recognizance, which means I will release you as long as you promise to go to court and comply with all of the written orders in your paperwork. Those orders will include that you're not to return to the scene of the alleged crime or have contact with any alleged victim or witness. You're not to possess any weapons, and you must obey any terms of any orders of protection that have been issued or may be issued. You may not reside with the alleged victim, even if you are the owner or renter of that property. You are allowed one civil standby with a local law enforcement officer if you need to return to the property in order to collect some of your essential belongings. Any violation of this no victim contact order, even if the alleged victim wants to have contact with you, could constitute you being charged with a separate felony offense. Do you understand everything I've told you, sir?
Yes, Your Honor.
All right. If you fail to appear or you fail to comply, a warrant can issue for your arrest. Do you promise to go to your court date?
Absolutely.
Thank you. Any questions?
No.
All right. Thanks, sir. You can step to your left. Alice, please. And then Abdul Haq to the chair by the door, please.
Good afternoon.
Good afternoon. Please tell me your full name and your date of birth.
Alice C.F. February 1707.
Thank you. I have you here on a new case. You're arrested on one allegation of shoplifting with an artifice, a class 4 felony, and one allegation of obstruction, a class 2 misdemeanor. I have found probable cause to support those allegations, and I'm appointing an attorney to represent you. You'll have court on March 27th and March 31st at 8:30 in the morning in the downtown Superior Court. I'm planning on releasing you on your own recognizance, which means I will release you as long as you promise to go to court and comply with all of the written orders in your paperwork. If you fail to do either one, a warrant can issue for your arrest. Do you promise to go to your court date?
Yes, ma'am.
Thank you. Do you have any questions?
Yes, ma'am. I'm a freshman at ASU, and I have classes like all week, like Monday to Fridays.
Okay.
And I was wondering what days are my court days.
So your court dates are, it looks like a Thursday and Monday.
Is it possible to get the Thursday switch? I have like classes all day on Thursday.
No. I mean, you can try and talk to your lawyer, but you're charged with a felony offense here. So I understand school is important, and I appreciate that you want to get to your school. But if you fail to appear at court, you could get arrested, and then you could miss even more school. Okay? So unless your lawyer is able to move those dates for you, I don't have the ability to change them. You're going to have to talk to your lawyer, which probably means you're just going to have to plan on missing missing school on the 27th at least.
Okay.
All right. Any other questions?
Yes, ma'am. Does this is this count as a felony? Like, I'm not sure if you're going to be able to answer that, but Does this affect like my chances to get into law school? I'm a law major.
I have no idea. That's a question for your attorney.
Oh. And what am I expecting, like, doing, like, my court days?
I'm sorry, what's your question?
Like, what am I to expect doing my court days, ma'am?
That's another question for your attorney. I can't answer that. Right. Any other questions?
No, ma'am. Thank you so much.
You're welcome. Go ahead and step to your left. Abdus, please. And then Ronald to the chair by the door, please. All right. Good afternoon, sir. Please tell me your full name and your date of birth.
Good afternoon. My name is Abdul Shahid Abdul Haq. September 2nd, 1997.
All right. Thank you, sir. So I have you here on a warrant for possession of narcotic drugs and dangerous drugs out of Hendricks County in Indiana. They want to take you back for those allegations. Before they can do that, you are entitled to what's called an extradition proceeding. Did you get a chance to read that laminated piece of paper?
Yeah, I read a little bit of it. I have one question really on it.
Okay, let me explain kind of what it says to make sure we're on the same page, and then I'll be happy to answer any questions that I can, okay?
Yes, ma'am.
So Hendricks County wants to take you back to Indiana. Before they can do that, you're entitled to an extradition proceeding. If you choose that option, what I will do is set your next court date here in Maricopa County on March 24th at 1:30 in the afternoon in the downtown Superior Court. You would be held on a $50,000 secured appearance bond. The extradition proceedings are essentially where you are demanding that a governor's warrant be signed by the governors of both Arizona and Indiana before they can take you back to Indiana.
Yes, ma'am.
That process of trying to get a governor's warrant signed by the state can take anywhere from 60 to 90 days. So if you can't pay your bond, you'd be held in custody during that time period while they're trying to get the governor's warrant signed. So that's kind of option number one. Option number two is if you know you want to go back to Indiana, you can waive your rights to an extradition proceeding. If you choose that option, you'd be held in custody without bail, and Indiana would have 30 days to come and get you starting tomorrow, assuming you don't have any other local holds, which I didn't see anything else. Do you,
no, I have
see any holds? Okay.
no charges here. I've been here since June of last year.
Right. So assuming you don't have any other local charges, which it looks like you don't, then Indiana would have 30 days to come and get you starting tomorrow. If you're not sure what you want to do, I can set your court date here in Maricopa County on the 24th, and then you can always do a waiver at that time. But I offer the waiver at this juncture because some people know what they want to do, and they want to get that 30 days started as quickly as possible. So what would you like to do?
I would like to go home.
I don't know where home is.
Indianapolis, Indiana.
So would you like to do the waiver?
Yes.
Okay. All right, I have to read some questions to you, and I need you to please answer out loud yes or no, because we're making a record, okay?
All right.
Did you read the waiver of extradition paperwork?
I didn't get a full chance to read the initial appearance side. I only read the state of Arizona side.
Okay, do me a favor, take a seat. I need you to be able, if you want to do the waiver, you have to be able to have an opportunity to have read it all. So I'll see you the next gentleman, and then I'll call you back up after you've had a chance to review it. All right, I'll see Ronald, please. All right, good afternoon, sir. Please tell me your full name and your date of birth.
My name is Ronald Amade. My date of birth is 11/29/66.
All right, thank you, sir. I have you here on a warrant out of Escambia County in Louisiana for failing to appear at your court date. In that
Out of what county?
It says Escambia, ESCAMBIA. Hold on a second, let me look at the actual.
Yeah, there's no such in Louisiana. They have parishes, not counties.
Sure.
And and there is no such thing as Escambia Parish in the state of Louisiana. Your Honor, if I may,
no, hold on one second. So it looks like the confirming agency is actually East Baton Rouge Parish.
That's correct.
Okay, just hold on one second. Thank you. Have a good day. Okay. All right. So I apologize for misstating the county, but it does look like the warrant has been confirmed, and they do want to come and get you on it. So did you get a chance to read that waiver of extradition paperwork?
Yes, I've been through it before, Your Honor. The thing that I wanted to say was that I'm no stranger to these proceedings, unfortunately. I've been extradited 5 different times, and not in connection with this, but just over a period of about 40 years. I'm 58 years old. I have a criminal background, admittedly. But this particular issue, I was released I did 12 years. I got out. Some laws changed in the course of my incarceration that rendered them unable to put me on supervision, and they just had to release me. Okay. So that happened. I left Louisiana. I went to San Diego, California, where I was born and raised. From there, I went to Orlando, Florida, and I was on the job mission. So, after 12 years, I was looking to hurry up and get employed. And when I got to Kissimmee, Florida, I was rearrested. And then they released the hold, and I quote, "Please lift the hold on Ronald L. Amadei. Charges are hereby have been dismissed." And then there was some other statement in there, "Please lift our hold." From that juncture, I came here. Now, I don't know what the mechanics are as far as what you're seeing, but if you look at my NCIC, it will reflect that I was arrested in 2023 or early 2024 in Kissimmee, Florida, and then you see me being released. And being released from the same agency, the very agency that's saying that they want me now. So if I'm out of their state, I do not have the ability to be in 2 different places at one time. Or in one place, and be here, or wherever the case may be. I've had police contact in the time that I've been away from the state of Louisiana. This is the first time, besides Kissimmee, Florida, where down there I was actually I was arrested and released, that I've ever had some sort of an issue. So I don't know what the system keeps being triggered on, for lack of better words to describe it. But each and every time that this matter has come up, to include immediately after my release from prison, I've been released repetitively, continuously. Every time the matter's been brought up, and I'm just wondering, at what point does procedural due process trigger to disallow a state from disrupting your life, especially post-sentence, when an incarceration term has already been completed? And I discharged. I didn't get out on good time. I discharged. I did 12 flat. So I'm just, and that was just something I just said on the fly because it's been a while, so I'm a little rusty. But I just don't understand you know, I don't think that the Uniform Criminal Extradition Law was crafted in order to allow a state to continuously go after the same person for the same matter repetitively and continuously without somebody having the ability at some point in some court by some judge to say, you know what, enough is enough. Okay. And I'm just curious as to when that's going to happen, because this makes 4 times.
Okay. I don't have any information that you were previously held on this warrant. If you were, it certainly doesn't sound like you were ever extradited to Louisiana on them.
No, ma'am.
So, I mean, I guess part of the solution would be going to Louisiana and addressing the warrant. But regardless, I don't see anything in the documents that I have that you have been arrested on this warrant before. You could have been. I just don't have any way to verify that. Even if you had been arrested 4 times previously on this warrant, the arresting agency has confirmed this warrant is valid. They are saying they want to come get you. Mm-hmm. So I don't know if things have changed since the last time you were arrested. I have no idea. All I can tell you is that this is a valid warrant, and they want to come get you on that warrant. So we have to talk about your options for today. If you think there's some due process issue that has arisen, you're welcome to hire a lawyer and address that. But for today's purposes, for this hearing, for this arrest, I don't see any constitutional issues at play before me right now. So what we have to do is make a determination as to what you want to do next. So it sounds like you said you're pretty familiar with extradition proceedings.
Yeah. I'd like to waive and just go ahead and go back and deal with it.
Okay.
There we go. Anything else? I mean, I'm very familiar with the process. We can go ahead and waive all the rest of it, because I already know.
All right, then I'm going to go through the waiver.
That's just making it easy.
All right, I'm going to go through the waiver with you. I need you to answer each question out loud, yes or no, please. Did you read the waiver of extradition paperwork?
Yes, ma'am.
All right. Do you understand that you do not have to sign this paperwork?
Yes.
All right. Do you understand that you have the right to an extradition hearing?
Yes.
All right. Do you understand that you have the right to hire a lawyer at your own expense?
Yes.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before you are returned?
Yes.
Do you understand that you have the right to bail?
Yes.
Do you want to give up those rights and sign this paperwork?
Yes.
Has anyone threatened you or promised you anything to get you to sign this paperwork?
Nope.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No, ma'am.
I find that you knowingly, intelligently, and voluntarily are signing the waiver, and I am also signing it. I am directing the sheriff's office to notify the requesting state that you are ready to return. The requesting state will have 30 days from tomorrow to pick you up, unless there are local charges pending. If there are local charges pending, that 30 days would not start until the conclusion of your local cases. Do you have any questions, sir?
No, ma'am.
All right, if you could please step up to my clerk, she'll assist you in signing your paperwork. All right, while we're waiting, I'm going to make a record of a house call. Anthony Contreras, October 3rd, 1994, is not present because he was combative, so I'll go see him in the facility. You're on a new case. He was arrested on 1 allegation of burglary, a Class 4 felony. I did find probable cause. I'm appointing him an attorney. He'll have court on March 18th and March 20th at 8:30 in the morning in the downtown Superior Court. He has a $2,500 secured appearance bond. I'm also ordering that he comply with all of the written instructions in his paperwork. Number 1 on the calendar, Jordan Krumbach, September 27th, 1996. Ms. Krumbach is not present in court according to the officers because she was disruptive, so I'll go see her in the facility. She's here on a new case. She was arrested on 1 allegation of possession of dangerous drugs, a Class 4 felony, 1 allegation of possession of narcotic drugs, a Class 4 felony, 1 allegation of possession of drug paraphernalia, a Class 6 felony. I did find probable cause. I'm appointing her an attorney. She'll have court on March 27th and March 31st at 8:30 in the morning in the downtown Superior Court. My intent is to release her to the supervision of pretrial services. If anything should change after I speak with either of these individuals, I will supplement the record by noting any changes in the written release order. Thank you.
Thank you.
You're welcome. All right, and then if we can get Abdus back, please. All right, sir, if you could please tell me your full name and your date of birth again.
Abdul Shahid Abdul Haq,
All right, and date of birth, please.
September 2nd, 1997.
All right. I believe when we broke, you had indicated that you wanted to do the waiver, but I needed you to make sure you had an opportunity to review that paperwork. Is that still correct?
Yes, that's correct.
All right. So I'm going to ask you a couple of questions. I need you to please answer out loud yes or no. Did you read the waiver of extradition paperwork?
Yes, ma'am.
Do you understand that you do not have to sign that paperwork?
Yes, ma'am.
All right. Do you understand that you have the right to an extradition hearing?
Yes, ma'am.
Do you understand that you have the right to hire a lawyer at your own expense?
Yes.
Do you understand that you have the right to demand that a governor's warrant be signed by the governors of both states before you are returned?
Yes, ma'am.
Do you understand that you have the right to bail?
Yes, ma'am.
Do you want to give up those rights and sign this paperwork?
Yes.
Has anyone threatened you or promised you anything to get you to sign this paperwork?
No, ma'am.
Have you had any drugs, alcohol, or medication within the last 24 hours?
No, ma'am.
I find that you knowingly, intelligently, and voluntarily are signing the waiver, and I am also signing it. I am directing the sheriff's office to notify the requesting state that you are ready to return. The requesting state will have 30 days from tomorrow to pick you up, unless there are local charges pending. If there were local charges pending, the 30 days would not start until the conclusion of your local cases. Do you have any questions for me?
Yes, and the result that haven't got me in 30 days, what happens then?
You're released, but the warrant is still valid.
Yeah, but I'll release from here.
Correct. Any other questions?
Yeah, one. But it is not going to stop anything in my decision making.
Okay.
Why isn't my name correct on there?
On where?
On anything.
What is incorrect about your name?
Everything. My name is Abdul Shahid Abdul Haq. I don't have a middle name.
Oh,
Nothing's been shortened. That's not my name.
You're just saying it's missing your middle name?
Yeah, it's like missing my name, period. I don't have a middle name. I wasn't, born with a middle name.
I see what you're saying.
So, my name is Abdul Shahid.
Abdul Haq.
Yeah, that's my last name. Abdul Haq is my last name.
I see. You're saying your first name is, it's like, I got it.
Yes, Abdul Shahid.
Okay.
So that's all I was kind of confused about.
Right. It looks like all the other identifying information in the warrant comes back to you. And in the actual hit, it does say that. It says Abdul Shahid, Shaheed.
Yep, that's
Abdul Haq. So it might just be how they entered it in here on the computers.
All right. I was just asking.
No problem. Go ahead and step up to my clerk. She'll assist you in signing the paperwork. All right, this will conclude the 2 p.m. initial appearance calendar. The court will stand in recess until 5 p.m.
Do I get a copy of that?
We're good.